Buckle up your seatbelts because we in for a long ride this evening. A long ride. So if you've watched my last couple of videos, what I'm about to explain to you this evening is going to help you out a lot in your journey. I've debated about whether I should even share this, but I'm going to anyway, because it's time for the American people to come up out of their slumber. And it's time for we the people to enforce the law, because that is our duty. People have a preconceived notion that law enforcement is the enforcer of the law. Ladies and gentlemen, I'd like to tell you, you, the American people, guaranteed a Republican form of government, are the law enforcement, because you are the source and the authority of the law. This whole system was created by us, by man, to benefit who? We, the people. All right, and it's predicated on sound doctrines and principles. But in ancient times, there were other systems afoot that migrated over here, called the law of the mother country. All right. And so you will see that if you understand, in the War of 1812, we didn't win our independence. The Civil War, there was nothing civil about it. It's an oxymoron. There's nothing civil about war in the first place. And they use a lot of language, whether it's intentionally to mislead and deceive people. I'll let you be the deciding factor of that. I'm not going to try and sway your opinion one way or the other. What I am going to give you is the facts and let you guys decide what to do with it. So we're going to be talking about court cases, the different venues and jurisdictions. I've already expressed to you public and private. If we get to it tonight, I'm going to show you the statutory equity that they speak of and how it's in harmony with Gibson's suits and chancery, subrogation, substitution, right of exoneration. All right. And suretyship. And I'm going to show it to you where it's found statutorily as well, because it's found in the GSA bonds. That's your equitable right of redemption, statutorily speaking. Comprehending that we, the American people, are the source of the credit. We are the creditor. If you've watched the other videos, you understand that the 73rd Congress, First Session, Volume 77, Part 1, very clearly articulates it and lays it out, that we, the people, are the source of the credit, that there's a mortgage on everything. And when I explain the court system to you tonight, it's in hopes that you will study this material time and time again, to finally ascend to the mind and comprehend what they're doing. All right. It's all about honor and dishonor. And it's taken a long time for me to get where I'm at. It's taken over 15 years. This is not something that is easily understood, especially if you've been heavily indoctrinated and brainwashed through the public fool system. Remember, they want you just intelligent enough to clock in at 8 o'clock, punch out at 5:30, have a beer at happy hour, and watch some football games and folly on Saturday and Sunday and believe that you are free. That's their objective. The best kept slave is the one who thinks he's free. All right? They never abolished slavery. They just changed it over into the prison system. That's all they did. They just changed the name of it, and slavery continues on even to this day. But it's our objective and our duty to study, show thyself approved, and come up out of her. That's what we've been commanded and compelled to do. This system is biblical. It goes all the way to the beginning of time, okay? And I didn't learn that until I was actually incarcerated in a prison system, and they took everything from me, and I knew there was one thing they couldn't deny me, and that was the King James 1611 Bible. And when I asked for that 1611 Bible, the trustee was a little perplexed and said, well, let me go see if we have any. He came back about 15, 20 minutes later and said, we're out of those, but let me see what I can do for you. And somebody that was in the prison system, who's going to be there for a long time, graciously lent me his Bible. And for the next 16 days, I read that Bible. And a lot of things started to come to fruition. A lot of things started to make sense. I'd been lost in the statutory realm. I didn't quite understand what was going on, but I knew in my mind, my body, my spirit, my heart, my soul, that something wasn't right. Okay? And for the inquisitive mind and the ones that inquire often find the remedy and results. So, here we go. The courts are operating under statutory law. It's important to understand what statutory law is. Okay? Why are you prompting me to do that? Okay, I see that. Statutory law is the law of merchant, Roman civil law. Statutory law is the law of the Pharisees. How can we validate that? Well, if you're spiritually inclined, when you're reading the Bible, 1 Timothy section 9 says the law of the Pharisees isn't written for the righteous man. It's written for the ones without a moral fiber or moral compass, knowing the difference between right and wrong. Americans' Institution on Law also expresses that the study of equity, the ones who study equity see the law for what it is versus the one who only perceive the law to be found through statutes and codes. Okay? Statutes and codes is more for the people who are deficient. Okay? And so they need optical glasses to see the law because they don't know the law. It's not written on their heart, or they haven't discovered it on their heart yet. Okay? But in statutory, there is equity within the statutes. And it took me a long time to be able to see the statutory equity, which holds a remedy in the statutes at law. But we also have the ability to go in law. The reason that we have to study the statutes is because that's the way that you're able to communicate with them, because they don't understand anything outside of their system. Think of it like programming a computer. I don't know anything about programming a computer. I don't know about the ones and the zeros that need to be there in order to, for example, display what you're seeing here today. All right, but we know that it exists. So we acknowledge that it exists. And if we seek to understand it better, we have to study and show thyself approved to be able to do this. On the back side of what you're seeing is nothing more than a computer-generated code of ones and zeros that allows us to see this image on the screen. Now, you don't have to understand how the computer programming works to enjoy the benefit, right? We get the benefit not knowing how the system works. But if you truly want to understand the system, you have to go on the back side in the back office to see how it's structurally set up to fully have a comprehension. And that's what we're going to do tonight. We're going to do the back side of the court system, okay, the Maritime Admiralty system that is running concurrent with the private side. We're going to show the banking aspect. This is all on law of merchant, law of mercantile. This is what they're operating under. And this system is as ancient as any system out there. I've seen reports that it starts clear back in 543 during the Justinian period, or during the rule of Justinian. All right, and so I have reason to believe that it even goes clear back then. So, the courts are operating under statute law. A statute is defined in Black's Law Dictionary, 4th edition, revised, as a kind of bond or obligation of record, being an abbreviation for statute merchant or statute staple. Another identifier for a staple or a statute staple is a tax, ladies and gentlemen. It's a tax. That's what it is, okay? Statute merchant. So we're dealing with contract. Contract creates the law. Equity follows the law. But most important to point out in the explanation by Black's Law Dictionary, 4th edition, is the fact that they're speaking of bond. Bond is what? Future interest, right? A bond is something that has value, monetarily speaking, under the law of merchant or the law of mercantile, all right? We're talking about obligation. What is an obligation? An obligation is a contract, okay? An expected performance, okay? So we have bonds and we have obligations. Remember, in the economic system that is afoot, there are only 4 elements: bonds, excise taxes, securities, and insurance. And you're going to see tonight that the entire court system that is set up is all dependent on those four elements. Okay? Bonds, securities, excise taxes, and insurance. That's the whole economy in a nutshell after 1933. All right? Statute merchant is defined as a security. All right? To our peace, our posterity, our life, liberty, pursuit of happiness, to our security, right? Security in the banking world is a monetary term. Under the law of mercantile, it's a monetary term. As a security for a debt. A debt is something of value. A debt is actually an asset. And if you don't believe me that a debt is an asset, then ask yourself why everybody swoons to buy debt. Okay? Because debt has value. Debt is a form of money. Okay? So we have security and we have a debt. All right? You have to understand that you're the creditor. You have to understand that you have the use of a debtor. Okay? You're the sestique, having sestique use of a construct that was created. A creature of the state, a creature of the establishment was created for your beneficial use, which is their liability. Okay? A debtor, a debt is valuable. So for a debt acknowledged to be due, entered into before the chief magistrate of some trading town pursuant to Statute 13 Edward the Mertobius, by which not only the body of the debtor might be imprisoned and his goods seized in satisfaction of the debt, but also his lands might be delivered to the creditor till out of the rents and profits of them the debt be satisfied. This was also called a pocket judgment. Okay? Now it's important to understand, when they're talking about warehousing the lands, your body is portable, movable landmass. It is generally tangible. Okay? So warehousing of the body as surety for the debtor, all right, is the lands that they're going to seize, the goods. The debtor is the all caps ens legis entity, estate, and Social Security account number, all right? The Social Security account number is manifested by the International Monetary Fund, all right? This is the account that they're fleecing. This is where they're siphoning off the credits or creating these negotiable instruments using this account number to grant access to the trust, to the estate. All right? And so if the debtor falls into dishonor by not fulfilling the obligation, then the lands will be seized. Your body will be seized and put in jail for the creditor. Now, this might be a little confusing because if you understand, the United States is a debtor. They're not a creditor. They're insolvent. All the banks are insolvent. They're all foreign to you and I, okay? And we are the creditors. But they're using this language to confuse us all. So we don't know who we rightfully are. We have to know who we are, study to show thyself approved, and stand on what's true, correct, accurate, not misleading. All right? So what they're really looking for is the debtor. And that debtor is the entity that they created. Okay? And they're creating constructive trusts in the courtroom. And they're putting these charges on, which are really attached to penal bonds. Penal bonds and sums. Okay? And penal bonds and sums have a value in this monetary system. There is no money. There's only credit and debit. Credit is a liability on the liability side of the ledger. And debit is the private side of the ledger that they're hiding from you. All right? We're going to explain that a little bit more. Statute staples equals A 1353. Statutes establish procedures for settling disputes amongst merchants who trade in staple towns. The statute helped merchants receive swift judgment for debt owed. CF statute merchant to a bond for commercial debt. Okay, everything they're doing is in the commercial realm. All crimes are in fact commercial. Everything they're doing in the court system, believe it or not, is civil. All right? And we can prove that because it's all attached to the monetary system. All right? In criminal claims and complaints, there's no monetary value there. George caused harm to Daniel, and George needs to go to jail for the harm, damage, loss that he has caused, right? On the civil side of it, bringing a civil suit is where you're getting your damages. That's on the commercial side of it, all right? So under 27 CFR 7211, all crimes are in fact commercial. And what the court system is doing is trying to deceive you by failing to disclose material facts, the nature and cause of the transaction within the courtroom, because they're hiding the fact that the charges are attached to penal bonds and penal sums, meaning they have monetary value. They don't want you to know that this is a banking transaction, all right? A bond for commercial debt, a statute staple, which is a tax, gave the lender a possessory right in the land of a debtor who failed to repay a loan, see staple, in the land. In the body. Your body is a portable, movable landmass. You have a title to your body. That title is that birth certificate. It's called a bill of lading, all right? And they're using that. They're claiming your body. This is the involuntary servitude, peonage, bondage, and slavery that they're not informing you of, all right? There's a title to your body, which is a portable, movable piece of land. And when the debtor goes into dishonor, because remember, the public debt can never be challenged. When they're charging up the estate, the second you go into quibbling and arguing and doing motions and motion to dismiss and all that, you've now fallen into dishonor. And I'm going to show you how that comes into play here in a minute. A popular form of security after 1285. Remember, this system is ancient. This system, they didn't just recreate this in 1933. They've been using this well beyond or before 1285. Was the statute staple. Again, that's a tax, whereby the borrower could, by means of a registered contract, charge his land and goods without giving up possession. What is lands and goods? Goods and services. The value you provide in physical labor is a goods. It's your precious valued time commodity is a good, and services, all right? Your performance is a service. The land is your portable, movable landmass, your body, all right? And they're saying when you're in breach of contract and the charge comes up that they can incarcerate your body and take your goods. What are your goods? Your precious valued time commodity, which has been pledged to the International Monetary Fund through the Congress to the IMF in order to do business. Giving up possession, all right? If he failed to pay, the lender became a tenant of the land until satisfied. The borrower, under a statute or recognizance, remained in possession of his land. Okay? So the borrower remains in possession of the land, and it later became a common practice under the common law forms of mortgage. Remember, I told you in 1933, what the Congress did in the 73rd Congress, First Session, Volume 77, Part 1, is they put a mortgage on everything. The seed in your loins, the eggs in your ovaries, the blades of grass in the front yard, the dogs, the cats, the birds, everything. They mortgaged everything. Okay, another word for mortgage is trust. They put everything into a trust. Likewise, to allow the mortgagor to remain in possession as a tenant, if you go look at your mortgage deed of trust, if you go look at your deed to your property, you will see that you're not on there, okay? It's a false and fictitious, unregistered, assumed business name, and they're calling that false and fictitious, unclaimed, unregistered, unassumed business, or assumed business name, or fictitious name, a tenant, at will or at sufferance of the mortgage. J.H. Baker and Introduction to the English Legal History, 354 3D edition, 1990. All right? If you don't believe what I'm saying, which I don't encourage you to just take me at my word or take this information at face value. Go do your research. Go pull your warranty deed, your joint tenancy deed, your trust deed, your deed in common, and see if I'm not 100% spot on that the entity will be named a tenant, which means it's a rentor, and the entity that acquired the property is in fact a trust under the name of Mr. and Mrs. John Smith, joint tenants in common. All right, or maybe you're just you were the sole signer of the documentation, and so it'll just be your first name, middle initial, last name, which is not you. Okay, it's a constructive trust, which is going to be labeled as a tenant. All right, and that's why people are paying property taxes, because they don't actually own their property. When you own something, you don't pay taxes on it. And if you do pay taxes, it's a one-time tax, like buying a toothbrush. You own that toothbrush. Year in and year out, you do not continue to pay taxes on a toothbrush because you've already paid the tax, which is an excise tax, which is rightfully due and owing back to you when you learn how to use the IRS. The IRS is your best friend. Let's continue on because we're going to be talking about the court system here. Recognizance, a bond. Okay, if you've ever been arrested and they say we're going to allow you on an OR bond. An OR bond is own recognizance. It's a bond. It's a monetary instrument. It has value or obligation. So an OR bond, an own recognizance, is a bond or an obligation or contract wherein you become the surety on behalf of the debtor, which is the all-caps entity with share charging up, of record, binding a person to some act as to appear in court and subject to forfeit money if obligation is not fulfilled. Well, if you don't show up, remember, this is a bond, and own recognizance is a promise to appear, most typically, is what it's issued for. And when you appear, the money that you may forfeit for failing to appear is, in fact, this bond. Your signature under the monetary system creates the credits on account, which are a liability. You got to move those credits from the public side back to the private side so you can debit them. They belong to you. Your performance, when you show up, you're entitled to this OR bond or own recognizance bond. You're entitled to these monies. If you don't claim these monies, you abandon them. You don't forfeit them. If you forfeit them by not showing up and performing, your failure to perform is a dishonor. And therefore, you have lost your right to the earnest monies you've created with your signature on your own recognizance bond, which is an obligation or contract. Contract creates the law. Equity follows the law, okay? So stay with me. Forfeit money if obligation is not fulfilled. In other words, you don't show up, all right? And you're coming in as surety on behalf of the debtor because, again, the public debt can never be challenged. They created the entity. The all caps ens legis entity belongs to the United States and is a United States citizen and is domiciled in the United States. Okay? FIFA equals FIFA. Short for the Latin phrase fieras facia, let it be made, was a court execution to the sheriff to levy, lien. Another word for levy is lien on, take the property of a debtor in order to satisfy a judgment. See judgment and an execution docket above. The sheriff might typically keep track of fiafis in a sheriff's FIFA docket book. All right, so the sheriff may have a FIFA docket book. We're going to have to investigate that and ask him where their FIF docket book is, okay? Because remember, all of these accounts belong to we the people. Usually written on a fill-in-the-blank form, a FIFA names the parties to the court judgment and the value of property to be taken to satisfy the judgment. On the back, the sheriff or his deputies annotate their actions in carrying out the order. The FIFA or FIFAs were to be returned to the court which issued them and the action annotated on the judgment docket. Theoretically, the docket books should contain everything that was noted on the FIFAs. FIFA is another word for warrant. Warrant is a check. It's a put call. It's money, okay? The charges, when they're generated, are already paid for. They've already drafted the instrument and they already have the credits. The credits are their liability. They're the debtor, okay? And as the creditor, when we convert those credits back over to the debit side of the ledger, the accounts receivable and the accounts payable, right? On the debtor's side of the ledger, right? Accounts payable, and we're on the asset side of the ledger, which is the private side of the ledger, which is accounts receivable. All right? And the way that you receive those credits, okay, is by the conversion of moving them over to the debit side of the ledger, which is your asset side of the ledger. I have been doing more research on our prison system via the internet and have found out some interesting things regarding what is really going on in the courtroom. The court is looking for the acceptance and acceptor under UCC 3-410. Remember how I told you that they're private for-profit ad hoc corporations masquerading around as a legitimate judiciary. They're actually Article 1, Section 8 military tribunals that belong in a territorial jurisdiction that is classified under Article 1, Section 8, Clause 17. They're utilizing the UCC because they're a private for-profit ad hoc corporation negotiating negotiable instruments because they're insolvent and debtors and they need your credit. They're hypothecating your credit into existence using benign statutes, codes, city ordinances, rules, and regulations that are directly attached to penal sums, which are bonds. They have value. They have a monetary number behind them. And what they're doing is getting you to come in and create controversy by arguing. When you go in and create controversy by arguing, okay, you're challenging the public debt. You've now fallen into dishonor. We have the credit. We are the creditors. We have the ability to go ahead and sign off on that warrant and make sure that the taxes are paid, and then they have to give us the remainderment and everything else back. When we fall into dishonor, they're able to sell the performance bond, bid bond, warehouse bond, SF 24, 25, 25A, the 273, 274, and 275 GSA bonds, okay? So under UCC 3-410, remember how I told you that statutorily speaking, and even in the code, there's always equity within it. You have to be able to see it. Of the UCC, the Uniform Commercial Code, as the principal has the primary obligation to pay or discharge any instrument presented for acceptance. In this scenario, you are the principal, okay? And you have to understand capacities, all right? You can be the surety. You can be the fiduciary trustee. Hell, if you want to be, you can be the fucking debtor, all right? I wouldn't advise being the debtor, all right? Because we already know, or operating in the capacity of the debtor, we already know who the debtor is. But we're the principal. We're the surety. We're the fiduciary trustee. When we learn how to manage our estates, all the bullshit stops, and life is a really beautiful thing. All right? So as the principal, if we go in and start arguing, we lose. They immediately sell the bonds to a disinterested third party that gets bundled up and packaged and ends up being mortgage-backed securities, and the judges love it. Why do the judges love it? Because part of their retirement is invested in mortgage-backed securities, okay, through another investment company. That's why they have to fill out the 1099-Rs, all right? Because they're investing in mortgage-backed securities as part of their retirement, all right? So as the principal has the primary obligation to pay, well, we know in the monetary system right now, as it is, there's only promises to pay something sometime in the future because all the substance under Article 1, Section 10 has been taken out of the economy. So how do we pay? We pay by accepting it for value and returning it, okay? And it's all about signatures because it's, again, in the economy, it's about bonds, securities, excise taxes, and insurance. That's the whole thing in a nutshell. All right? Obligation to pay or discharge any instrument presented for acceptance. We fall into dishonor when we don't accept the charging instrument. It doesn't matter what the charges are. It's irrelevant. They're trying to get you to argue the minor issue while subverting the major issue. And the major issue is the fact that they just need you to authorize the new currency into existence. Okay? They need your participation. Since they are presenting bill of exchange, it's a bill of exchange. It's called an indictment or a warrant. Okay? It's a negotiable instrument. And we fall into dishonor by not accepting it for value and returning it for the same, for a full settlement and closure of the account, because the docket number and the case number are actually bank accounts. They're FDIC insured, ladies and gentlemen. Remember, under War Powers Act, under military occupation, in the War Manual, under the Lieber Code, Executive Order 2, Executive Order 31, Executive Order 100, Article 2, Article 31, and Article 38, in the Executive Order 100 under the Lieber Code, during time of military occupation, the DOD, the Department of Defense, takes over everything, including the monetary system, all the minerals, all the value, all the grain, everything goes underneath the control of the occupying military force. So those Federal Reserve notes are military script. You're not supposed to be using them, by the way. Since they are presenting a bill of exchange indictment for acceptance, you need to accept it. By not accepting it, you immediately go into dishonor, and you give them the ability to sell it to a disinterested third party, and they put it on a secondary market known as the stock exchange, and they get millions and millions of credits on account on their ledgers due to our dishonor. When we dishonor the instrument, we are challenging the public debt, and nobody is allowed to challenge the public debt as it violates public policy. This is called an acceptance for honor, which involves a negotiable instrument, especially a bill of exchange indictment, the charging instrument, which they never give you. They never give you the charging instrument, because if they actually gave you the charging instrument, you would be able to see that this is just simply a banking transaction that has been accepted for payment. The complaint information or indictment is a three-party draft. Okay, it's a draft, commercial paper that then can be taken to the comptroller of the currency and redeemed dollar for dollar under 48 Statute at Large 112. Okay? Or bill of exchange under Article 3 of the UCC. The grand jury foreman is the drawer or maker of the indictment by his signature. You're going to find out signatures are very valuable. The defendant debtor, which is the all caps ens legis entity that was probated at your birth by the state registrar, which is a chief probate officer, okay, or straw man. Many people believe themselves to be this thing. This is a thing in rem. Okay, the evidence that the estate exists is it's already been probated by a chief probate officer known as a state registrar. Why people think that they are this entity or this thing is it starts with the DMV when you get a learner's permit and they capture your image and put it on a piece of plastic and they wave it around and go, "Is this you?" And people go, "Yeah, that's me. That's my driver's license." It's a horrible place and position to put yourself in. That is an inanimate object. That is a thing. It may have your likeness on it, but it is a form of idolatry. All right? It is not you. But when you claim it, you become it. Because under Article 1, Section 8, the military tribunals that they are running, everything is based upon presumption and assumption. There are no facts and there are no laws that will ever be charged in an article or ever be tried in an Article 1, Section 8 military tribunal. Ever. So what do you have to do? You have to be able to verify what they're doing, okay? And in order to verify what they're doing, which is nothing more than banking and accounting, you have to be able to articulate the following information that I'm going to give to you, all right? The defendant debtor or straw man is the drawee. The drawee in the Uniform Commercial Code is always the payer, okay? The payer is the debtor. That's the Social Security account number along to the birth certificate credentials that open up Pandora's box to allow the stream of credit to flow into the economy that then and there creates debt. You can have credit without debt, but you can't have debt without credit. Credit must always come first. This is how they get the stream of credit, which is their liability. They made the charges. They're the ones liable for them. If I order a cheeseburger, okay, I've created a charge, and when I get to the window, they're going to want what? Payment, right? Before I get the cheeseburger, before I get the goods, there's an expected performance on my end. I made the order, so they gave the value and consideration and giving the food and cooking it and the manpower and the time to cook it and process it. Then I get to the window. Because I made my order, they gave the value and consideration up front in good faith, and now they expect me to do what? Pay, okay? And then when I pay, I get the goods, I get the services. I pay the excise tax, I get the services. Then I go back to the IRS, and I let them know with my receipt, which is actual cash value of a special deposit, a transaction being made that I'm doing owing back, okay? That's the beauty of the IRS. So the defendant, which is really the all caps ens legis entity, is the drawee responsible to pay. What is the all caps ens legis entity? It's actually a constructive a construct of the United States, which is a for-profit private corporation under Title 15 or Title 28 United States Code 3002-15A, B, and C. Okay? So who owes the debt? Who carries the primary active degree of fault for the defendant, debtor, all caps, ens legis entity? That's the United States. Do you have evidence of that? Yes, you do. You have what is known as a warehouse receipt or a bill of lading, which proves they owe you a duty. And that duty is to put back into you your credit. The credit must always return to its source if you understand how this system works. And this system of credit can be recycled. Credit is a liability. You're going to put it over on the private side of the ledger. And then you're going to debit it from there and make it fungible and use it, which brings up the GDP, the gross domestic product, and the taxation for which the governments purport to run on. Okay? It's just an excise tax. The drawee and the state is the payee, and the live man or woman is the payor. Okay, so this is the constructive trust that they create in the courtroom, all right, where they're trying to make the living man or woman the debtor, okay, but in reality, you're the surety, okay? You're going to cover the United States because the United States is that defendant, straw man, United States citizen, juristic person, okay? And we're going to extend our full faith and credit in the United States, not challenging the public debt, but going into honor right away and accepting and acknowledging and returning for value the indictment or the charge. So we're not in dishonor because we're not arguing about any of it. What they are doing in the courtroom is all commercial, but they're hiding it underneath the guise that it is criminal in nature. Well, it's very easy to figure out whether or not it's criminal in nature, ladies and gentlemen, because where is the aggrieved man or woman making a claim under the pains and penalties of perjury, independently bonding their claim with a sworn affidavit under jurat stating who, what, where, when, how, and why they were caused harm, damage, loss? Under the Sixth Amendment, you have the right to face your accuser. Under the Seventh Amendment, you have a right to a trial by jury in an Article III court. Okay? And you're being denied those things. But again, I just say that and I iterate that just so you understand that when they're alleging that it's criminal, there must be a man or a woman aggrieved. Not a corporation, not a corporate fiction, not an agent who works for a corporation who's alleging that their corporation has been caused harm, damage, or loss. Those are all fictions. Okay? In reality, when they say it's criminal, there must be an aggrieved man or woman stating a harm, damage, loss, or a hardship that you have caused them. If that does not exist, we automatically know that this is a commercial, civil matter, okay? And in the Article 1, Section 8 courts, it's always a presumption and assumption that there's a civil contract amongst us all that binds us all. And one of those civil contracts is that we all agree that the public debt can never be called into question and is in conformity to Title 27 CFR 7211. When you go read that, you really quickly realize that the M word, the R word, grand theft auto, larceny, all these things are all just commercial, and they're attached to penal sums and penal bonds. All right, so when they're charging you up, they're not fully disclosing the nature and cause of the transaction, which is banking, where they're taking these charges, and on the back side, behind the paywall, is where they are affixing the monetary value. Okay, where it says all crimes are commercial, what the judge and prosecutor are doing in the courtroom is making a commercial presentment under sections UCC 3-501. Remember, again, it's commercial. They're operating under the law of mercantile, the law of merchant. We're under military occupation. They're usurping power, otherwise not delegated to them constitutionally speaking. But instead of arguing, it's so much easier to go to honor, understanding what they're doing. They're making a commercial presentment, okay? And if you don't accept that commercial presentment, you've gone into dishonor. And now they're going to try and hold the land, which is your body, as surety, while they shop around and sell your bonds that they hypothecated into existence under these charges, okay, that are attached to penal sums, which creates these GSA bonds, and they're going to sell them to a disinterested third party who is the innocent purchaser. And now they have a duty to lock up your body, your land mass, your goods and services, your precious valued time commodity, to ensure that you don't interfere with it, all right? Because you went into dishonor. So now they're going to lock you up. So the commercial presentment under sections 3-501, 1, unless excused, section 3-511, presentment is necessary to charge secondary party as follows. Okay, well, here's the issue. You've never actually been given a true and proper presentment. They're never giving you the charging instrument that you need to endorse to remain in honor. So we need to demand that. A, presentment for acceptance is necessary to charge the drawer and endorsers of a draft where the draft so provides or is payable elsewhere than at the residence or place of the business of the drawee, or its date of payment depends upon such presentment. The holder may at his option present for acceptance any other draft payable at a stated date. B, presentment for payment is necessary to charge any endorser. C, in the case of any drawer, the acceptor of a draft payable at a bank, remember the Article 1, Section 8 venues, the bench in Black's Law Dictionary is a bank, and the judge is a banker, and when you look them up, they're circular in nature in Black's Law Dictionary. Judge is banker, and you look up banker, and banker is judge, and you look up bench, and bench is bank, and you look up bank, and bank is bench. So they're circular in their explanation and their nature, okay? Or the maker of a note payable at a bank, presentment for payment is necessary, but failure to make presentment discharges such drawer, acceptor, or maker or only as stated in sections 3-502(1)(b). If you don't accept the charge or presentment, you are in dishonor. This is where they're getting people right here. They want you to be in dishonor, because when you go into dishonor by arguing and failing to accept and acknowledge, and you're challenging the public debt, which is a violation of the public policy, they're able to take those bonds and put them in a secondary market, and they yield a tremendous amount of value over the next 40 to 50 years. And it ends up being a mortgage-backed security at the end, which is exactly what all the judges sitting on the bench is retirement is not solely dependent upon, but is heavily influenced by, okay? Because their retirement company invests heavily in mortgage-backed securities, they're financially incentivized to lead you off the beaten path and to let you fall into dishonor, because they're financially rewarded on the back end, okay? If you don't accept the charges or presentment, you are in dishonor for no acceptance under UCC, Uniform Commercial Code 3-505 of the UCC, C, and 3-501 2AB, acceptance is the drawer's signed engagement to honor the draft as presented. It must be written on the draft and may consist of his signature alone. It becomes operative when completed by delivery or notification under UCC 3-410 of the Uniform Commercial Code. You are the fiduciary trustee of the straw man. Remember, you have sestake use of it. Okay, you don't own it because ownership is the devil's trick. When you own something, you carry the primary active degree of fault and liability for it. Who owns the straw man debtor? It's a creation of the United States. It is owned by the United States. It is, for all intents and purposes, a United States citizen. It is a thing in rem. Fiduciary trustees, ladies and gentlemen, get paid. You are a fiduciary trustee of the straw man, which is a sestake United States trust under the Sestake V Act of 1666. All right? In this capacity, see that word capacity, not status? You have the responsibility to discharge all his debts, all its debts. It says his debts, it's a thing. Its debts, okay? And how do you discharge its debts? Through your qualified endorsement, because you're the creditor. You're the fiduciary trustee having power of attorney, being the attorney in fact on behalf of the principal to authorize the transaction. When we don't authorize the transaction, we're challenging the public debt, we fall into dishonor, and we're violating public policy. Okay? When you facilitate this transaction as the trustee, the fiduciary trustee, gets paid because involuntary servitude, peonage, bondage, and slavery are illegal and unlawful. They're trying to get you to fall into the position of dishonor and become the debtor. Don't make that mistake. By operation of law, you are also the principal or asset holder on the private side of the accounting ledger. Remember, this is all banking. It's a T-ledger double bookkeeping entry system. Okay? And now we're going to be talking about the asset holder. How do we prove that you're the asset holder? Again, when you go to Executive Order 100, the Lieber Code, Article 38, a certificate of indemnification has been issued to you. When you look up the 73rd Congress, First Session, Volume 77, Part 1, it says in there that they amended the Trading with the Enemy Act, the trust indenture. And we go and we look at 40 Statute at Large 411, Section 7E, and you quickly realize that the President, the Commander-in-Chief of the largest military force in the world, has issued you a certificate which can be deposited in all venues and is to be received as power of attorney, making you the attorney in fact, proving that you are the holder in due course. On the private side of the accounting ledger, you are holding the exemption necessary to discharge the debt because you're the creditor. You hold the exemption. You hold all the power to forgive them. Forgive those who trespass against us as we expect to be forgiven for our trespasses, right? When they monetize the debt, they have to have a principal. Capital and interest is what circulates as principal and is called revenue or revenue. Principal is where venue lies. Revenue is a tax debt circulating as principal and is called, as a tax debt or tax bill. Remember, there are only four things in the economy: securities, bonds, excise taxes, and insurance. That's it. That's the whole economy after 1933. All bills, when presented, represent revenue, interest, capital, or accruals circulating from you as the principal. Again, you are the principal. You are not the debtor. You are the principal. You are the surety. All right? The debtor is the United States. The debtor is the all caps ens legis entity. Although you're in constructive possession of it and you have the right of use of it, who carries the primary active degree of fault for all its debts? The owner, the creator, the authority, the author, which is the United States. Okay? When it is returned back to you as capital or interest, it is called income or incoming. This method of accounting is called accrual accounting method. GAAP accounting principles, generally accepted GAAP accounting principles, accrual accounting method, and is represented by debits and credits. Credits are a liability, debits are the asset. Debits are your side of the ledger. Credits are their liability on their side of the ledger as the debtor. When they're holding the credits because you haven't moved them over to the asset side of the ledger to debit them, okay, you're in dishonor and the accounting can't be fulfilled and the taxes can't be paid. And now we have a major catastrophe. Debits are assets, credits are liabilities. The credits and liabilities have to be in balance. You have to balance the ledger. How do we balance the ledger? By acceptance for value and remaining in honor. This is accomplished through double bookkeeping entries or reverse bookkeeping entry. These bookkeeping entries are the funds referred to in the commercial banking. When you are in dishonor, they cannot use your exemption to pass the debt or charge through your account to obtain a discharge. So they sell your dishonor, which has commercial value of at least $1 million for each count. All right? Now, at one time I was in contact directly with a DTC agent. Not the DTCC, but a DTC agent. He said that the lowest bond that he had ever seen came from a 3 to 5 mile an hour traffic citation. 3 to 5 mile an hour over the speed limit traffic citation. And it was for $4.5 million. 4.5 million credits on account. And that was for 3 to 5 mile an hour over the speeding ticket. He told me, and this is just hearsay to you, that felony charges are anywhere from $8 to $10 million per charge. Okay? When Social Security number is assigned or a blank bond is issued, and when you are imprisoned, the bond is filled out. This bond is called a bid bond. Okay? So you got the SF 24, 25, and 25A. That's for the lower county, state, city bonds. Okay? The federal level, and we have to learn how to insure the federal government from any loss they may sustain, is SF 273, 274, and 275. Write those down. They're so fucking important because you are the source and authority and author of the credit, the extension of the credit. Okay, so the bond is called a bid bond, standard form 24, 1098, prescribed by GSA FAR 48 CFR subsection 53.228. You can go look this up. All right, 48, Title 48, Code of Federal Regulations, subsection 53.228A. This is also called a prison bond. These are also referred to as contract surety bonds. What is a surety? A surety is somebody that's guaranteeing something. All right? There's a guarantee of the transfer of funds. My phones are acting goofy. They don't like this information being out there. The first, the bid bond, provides financial assurance, not insurance, assurance. These are also, that the bid has been submitted in good faith and that the contractor intends to enter into the contract at the price bid and provided the required performance and payment bonds. The second, the performance bond, protects the obligee from financial loss should the contractor fail to perform the contract in accordance with the term and condition of the contract documents. Your juristic person, the United States created, is the officer, okay, is a contractor. The third kind of contract bond is the payment bond, which guarantees that the contractor will pay certain subcontractors labor and material bills associated with the project. On April 9, 2002 at 12:18 p.m., Liam Brothers Banking Cartel in New York City agreed to provide prison industry leader CCA, Corrections Corporation of America, with a new $695 million senior secured credit facility to be combined with a $150 million notes offering. The war on terrorism has created a buzz in the private prison industry. It's a private prison industry. Remember when I told you they didn't abolish slavery? They just renamed it and then moved it over into the private prison industrial complex. Less than 3 weeks after September 11th, a New York Post story on the for-profit private prison industry stated, America's new wall of homeland security has created a big demand for cells to hold suspects and illegal aliens who might be rounded up. In order to prosper, prison operators need to maintain a steady flow of prisoners and prison dollars. One of the industry's tools for accomplishing this is the American Legislative Exchange Council, a powerful right-wing lobby group that helps corporations draft and enact model legislation. What are they talking about? New statutes, codes, city ordinances, rules, and regulations that are supported on the back end by penal bonds and penal sums under the penal code for a price. Industry leaders, CCA, and WACHUT have paid tens, if not hundreds of thousands of dollars in exchange for the privileged position on ALEC, Criminal Justice Task Force, which CCA chairs. ALEC, in turn, not only promotes privatization, but also brags of having helped enact truth in sentencing, kind of like the truth in lending, but truth in sentencing, and 3 strike laws in 25 states. In addition to investing heavily in groups like ALEC and the Reason Foundation, the industry spends millions on campaign contributions. From 1995 to 2000, CCA, WACHUT, and Cornell spent $520,000 in federal elections, and in 1998, the industry spent $540,000 on state elections, where a little money goes a long ways, ladies and gentlemen. Corporations work on the physical accounting cycle because they operate using commercial debt. Remember, debt and commercial debt are of value. Okay, the Congress is always wanting to do what? Raise the debt ceiling. So if they have access to an unlimited amount of debt, there must be a group of people out there that have an unlimited amount of credit, right? We as owner principals work on a general calendar accounting year or cycle. New York City has $6.6 billion deficit. This deficit represents unredeemed debt. This means there's credit out there that hasn't been put on the private side and debited. $6.6 billion to be exact, that is owed to the people of the New York City. On the credit side of the accrual accounting system, and cannot be executed to the debit side of the accrual accounting ledger, except through the principal's exemption. It's our exemption that moves the credits and their liability to the private side that then can be debited to us because they're using our exemption. New York has therefore put its bonds underwriting business upon forbid. This means that New York will issue $6.6 billion in bonds and pay underwriters over $30 million in fees in the next fiscal year alone. Lehman Brothers Bank will underwrite New York's $6.6 billion deficit. An underwriter is an insurer, not assurance, but insurance, or one who buys stock from the issuer with an intent to resell it to the public or an entity or person, especially an investment banker, who guarantees the sale of newly issued securities by purchasing all or part of the shares for resale to the public. The term underwriter derives its meaning from former British insurance practices. When insuring their cargo, shippers would seek out investors to insure their property. The insurers would add their signature and would write their names under those of the shippers. Hence the term underwriter. That's exactly what you are. You are an underwriter. When you're extending your exemption, you become the underwriter of these bonds. That's why they always want your signature. You're the underwriter. You're the surety. You're guaranteeing something, both in terms of the insurance industry and securities market. The concept of underwriting have expanded significantly since its inception. West Mutual Shippers Association out of Luxembourg is underwriting Social Security Administration as surety ship contract or bond. Now you know how they are financing the commodities and securities market, and why New York City is called the Great Whore of Babylon in the book of Revelations, chapter 18, verses 10 through 24. The Corrections Corporation of America owns most of your prison systems and sells its stock and share on the New York Stock Exchange. The major stockholders is the Paine-Webber Group. They have a Duns & Bradstreet rating and are headquartered in Nashville, Tennessee at 10 Burton Hills Boulevard and can be reached at 1-800-624-2934. Their ticker symbol, and this is important because everything is being exchanged on the stock market, okay? Including your prison warehouse bonds and all these things that you have abandoned throughout your years, all right? That all caps ens legis entity and all the contracts you enter into are valuable, and they generate securities and bonds from those contracts. Contracts are money under the 73rd Congress, First Session, Volume 77, Part 1. Okay, the Congress redefined what money is. They didn't redefine what the dollar is. They redefined what money is. Notes, drafts, bills of exchange, bankers' acceptance, and trade acceptances. So they could have an elastic form of currency. Currency, the new money. Their ticker symbol for their stock is CXW, all caps, underscore PB on the New York Stock Exchange, and CXW under business services on the New York Stock Exchange. In Berlin, Germany, their ticker symbol is CXW period BE, all caps, and CXW period DE in Frankfurt, Germany. There is also a prison realty trust called PZN, Prison Realty Trust, which is Real Estate Investment Trust, REIT. Have you guys ever heard of Reddit? The Real Estate Investment Trust, okay, Freddie Mae, Fannie Mac, all that good shit, and is the world's largest private sector owner and developer. The American Legislative Exchange Council is owned by Paul Weirich of the Free Congress Foundation and receives financial support from all of your major corporations. They are the moving force and promoter of the National Council of State Legislators who privatize criminal statutes for financial gain and profit. In other words, they attach statutes, codes, city ordinances, rules, and regulations to penal sums and bonds. They are promoting public policy in regard to prize and capture law under the War Powers Act, under the DOD, Department of Defense, under military occupation. The Reason Foundation is run by, hold on, I got to do a thing here with the TikTok. They are promoting public policy in regard to prize and capture law under the War Powers Act. The Reason Foundation is run by David Nott, N-O-T-T, the president, and is a think tank promoting privatization of penal institutions for financial gain. Remember, the penal code is backed by penal sums and bonds. Privatization of the penal institution for financial gain. They are located at 3415 South Sepulveda Boulevard, Suite 400, Los Angeles, California, 900341. The phone number is 1-310-391-2245. The Wackhut Corporation is a U.S.-based division of Group 4 Flack AS, the world's second largest provider of security services, and is based in Copenhagen, Denmark, and is the premier U.S. provider of contract services to the businesses, commercial, and government markets. The types and techniques of privatization are contracting out, also called outsourcing, management contracts, public-private competition, also called managed competition or market testing, franchise, internal markets, vouchers, commercialization, also referred to as service shedding, self-help, also referred to as transfer to nonprofit organizations, volunteers, corporations, asset sales or long-term lease, private infrastructure development, and operation. Cornell Correction Incorporated, New York Stock Exchange, ticker is CRN, is chaired by David N. Cornell, and their company's concept began December 7, 1990, right around Slick Dick Bill Willie Clinton's operation, right? It was a rough business plan, yet the Dillon Reed Venture Capital became their first investor on February 21st, 1991. All right? That's when Bill Clinton was in office. Hillary Clinton was there. All right? They are also called Trinity Venture Capital, and Shane Rehill is the chairman and founder. They built correctional facilities in Plymouth, Massachusetts. The other in Central Falls, Rhode Island. They have grown 33-fold in revenue and offenders under contract since that time. They have diversified and are now dependent upon development and have diversified into the three. I'm being warned on TikTok for a warning. I'm not sure what for, but TikTok don't like it. I don't know if that means I have to stop my TikTok video and restart it. Maybe I ought to do that at a safety. Let me end now and I'll restart.
The biggest lie you've ever...
Boy, TikTok don't like it when you start giving this information out. Alright, we're back. I'm going to give TikTok, the people that follow me on TikTok, a moment to join back with us here. Bear with me if you're on Facebook. Yeah, I see you've been locked up many times. We're going to show you how to go back after their bonds. This is going to be a long evening for me. Years ago I made a guarantee to a couple of people sitting on a bench, and I told them I'd spend the rest of my life burying these people. And they said, "Is that a threat?" And I said, "No, it's a guarantee. It's a fucking fact. I'm relentless." And they perceived it as a physical threat. Well, my intent and what I say when I say it versus their opinion and their presumption and assumption are two different things. And unless they can prove my intent, good luck. So they can press their claim all they want. I think now they firmly understand what I'm talking about. So let's continue on. Got our followers coming back. I had to shut down the TikTok. I was warned. And people say that if you shut it down, they won't bar you from continuing on. But obviously they don't like this information. Their institutional revenues are around 42%. Juvenile revenues approximately 40%, and pre-release revenues are around 18%. These factors represent the outgoing phase of the prison system. All right, They've converted the family court system, which is really under the executive branch. It's all administrative. What are they administering? They're administering a bankruptcy, ladies and gentlemen. They are insolvent and they need your credit desperately. So what do? They create statutes, codes, city ordinances, rules, regulations. Why? Not because you guys are demented or deranged by any means, but because they need you to violate these things they've created so they can justify creating bills of exchange, drafts. All right? And their hopes is that you'll fall into dishonor so they can monetize it, whisk it away, and eventually it'll become part of a chocolate-covered turd package deal called mortgage-backed securities, which they're heavily invested in for their retirement portfolio. They're absolutely financially incentivized in not disclosing this information to you. This company is currently operating in 5 different time zones and is headquartered at 1700 West Loop, South Suite, 1500 Houston, Texas, 77027. Phone number is 1713-235-9366. Dillon Reed Venture Capital, a New York-based corporation, merged with S.G. Warburg in 1997, creating Warburg Dillon Reed. London-based UBS Warburg is the investment banking division of the Swiss giant UBS, one of the largest banks in the world. It has some 40,000 employees spread across 40 countries. This bank was started by the Paul Warburg family, which owns and controls the World Bank and started the Federal Reserve System. UBS Warburg is located at 141 West Jackson Boulevard, Chicago, Illinois, 60604. Privatization is the transfer of assets or service delivery from the government sector. Prisons are nothing but warehouses for the storage of goods and chattel under commercial law. Wait a second here. Everybody follow what I'm laying down? Y'all picking up what I'm informing you of? It's time for the American people to see what's really going on. What's really afoot. And so I hope this helps you out. The warden is a bailee. We are the bailors, all right? The warden is a bailee or warehouseman. Before the term admiral, remember they're operating in maritime admiralty jurisdiction, law of mercantile, law of merchant. And all these charges are directly tied to penal sums and penal bonds. You're not being provided full disclosure in the aspect that they're not explaining to you the nature and the cause. They're going to tell you the cause. You violated some benign statute, code, city ordinance, rule, regulation. They're not going to tell you the nature, because then that would show you that the nature is a banking transaction. They need your credit. They need your authorization. But when you freely give it, they have to give you all the rents, profits, and proceeds. You step in the role of creditor and you are due and owing all rights, titles, and interest, baby. They don't want you knowing that. Before the term admiral was used, he was called customaris, warden of the sea. All right? They're absolutely, without question, equivocally in Article 1, Section 8, military tribunals on our land, on our soil, engaged in mixed war against the Constitution. I don't say that so you'll go in there and argue. I'm trying to tell you not to argue anymore, but it's important to understand what they are doing. They're trying to drag you into a foreign dry dock using foreign law, which violates Article 1, Section 10. Ex post facto law shall not be passed. Bills of attainder shall not be had. Okay? No letters of marque, letters of reprisal, any of that shit. But that's what they're doing. And it's because we've been indoctrinated to believe that all caps thing in rem is us. And we come in and we are substituted for that thing and become liable. In some ancient records, he has called Captainus Maritime Murmur, or captain or tenant in chief of the maritime, who receives personal property from another as bailment. Bailee-bailor relationship for property or persons of another as bailment. They're holding it. The bailor is one who provides bail as a surety for a criminal defendant's release, also spelled bailor. Remember, we're actually the bailors. Okay? They're the bailees. We're bailing them out. We are the bailors. The United States is defunct, in debt, insolvent, Chapter 11 bankruptcy. We are the creditors. We are the bailors. They are the bailee. Bailment is the delivery of personal property by one person, the bailor, to another, the bailee, who holds the property for a certain purpose under an expressed or implied in fact contract. Remember, in the Article 1 military tribunals, it's all under presumption and assumption. So it could be orally expressed, it could be writtenly expressed, it could be physically expressed, or it could just be simply implied. That's why in the Article 1, Section 8 military tribunal venues, they have fact pleading and they have notice pleading states. There doesn't have to be a fact in the court. There are no facts in question. The only question is, are you going to be in honor? Are you going to go into honor and accept the charges and the value of those charges and compel them to use your exemption to set off and settle the account? Or are you going to go into dishonor and start quibbling about how it doesn't apply to you? You didn't do that. You didn't do this. They're liars. I want to subpoena them. I want a motion to continue. I want to do all this gobbledygook shit and go into dishonor. The choice is yours. Are you going to demand the charging instrument so you can properly endorse it, accept it for value, and compel them to use your exemption for settlement and closure? Goods are tangible or movable property other than money. So, goods are tangible or movable property other than money. While your body is a portable, movable landmass. You have a warehouse receipt for your body called a bill of lading. Not different, very different from a bill of attainder. A bill of attainder is a bill of pains. A bill of lading is a manifest. A shipping cargo manifest. Okay? And your body has a title. It's portable, tangible, movable landmass, and it's different than money. Especially articles of trade or items of merchandise. They turned your body into merchandise, which is exactly what the Heavenly Father is telling us in the good book. Come up out of her. Don't stand in as surety for anyone or anything. Okay? The sale of goods is governed by Article 2 of the UCC. Goods means all things. All things. Things are in rem, including specifically manufactured goods. Okay? Manufactured goods. Under Title 7 United States Code 163, subsection 31, any hairy vertebrate mammal that breathes oxygen, including but not limited to man, is classified as an animal under the agriculture. Under agriculture. Okay? So when they're issuing these birth certificates and claiming you as merchandise, they're claiming you as an animal, as a product that was manufactured. How are you manufactured? Hopefully it was a whole lot of heat, pressure, and love. That's how I find most good things are created. Heat, pressure, and love. Whether that be in a tent or the back of a 1986 fucking station wagon, I don't know. That's for you to find out. But you are considered a manufactured good in their system that are movable at the time of identification to contract for sale and future goods. You realize the definition for child is chattel paperwork that can be bought and sold. Okay? The infant died at the hospital. The child is the chattel paperwork that was probated, creating the estate, and the baby went home with mom and dad. The animal, under the agriculture. Okay? Under Title 7 USC 136, subsection 31. The term includes the unborn young of animals. There it is. How do I know this? How can I speak so assertively to these facts? Well, when you read the 73rd Congress First Session, Volume 77, Part 1, you realize very quickly, not only was there an economic banking emergency, but there was an agricultural emergency. So from March 4th to March 9th, they also deliberated. If you read the 1,176 pages, they also tell you about the agricultural emergency that happened because they were tying all this together. This was in the making for 100 years, maybe 50 years to 100 years before they actually enacted it. They all had it drafted up and drawn up. It's brilliant what they have done. The system they have created is amazing. The ingenuity and architecture to fabricate something like this is mind-boggling. And it was a group of people that did it, not just one single individual that created this plantation that you're on. Growing crops and other identified things to be served from real property. The term does not include money in which the price is to be paid. The subject matter of foreign exchange transaction documents, letter of credit, rights, instruments, investments, property, accounts, chattel paper, deposit accounts, or general intangibles, UCC 2-102A24. Go to the Payne-Weber group on any search engine or go to www.transnational.org/pays/USA lowercase s PHTM and open it up. And you will see the 20 largest companies, aerospace, food chains, credit card companies, banks, insurance, media, auto, biotechnology, chemical, consulting, construction, cosmetic, waste management, defense, retail. Not sure what that one is. Conglomerate. Water, electricity, appliances, electronics, packaging, energy, school, equipment, finance, holdings, hotels, real estate, computer, recreational, materials, medical, mining, fashion, motorbike, paper, private person, pharmaceuticals, United States Postal Service, CNF Inc., printing and publishing, advertising, restaurants, healthcare, service, metal, tobacco, telecommunications, textile, apparel, tourism, transportation, and staffing. This group is the United States of America and is the largest stockholder in the world in Corrections Corporation of America that owns and controls the entire world prison system through you and is funded by your commercial dishonor. Again, how all this is funded is because we go into dishonor. Now people are going to say, well, Derek, that's not fair. We didn't know. Nobody taught us this in grade school. Nobody taught us this in middle school. Nobody taught us this in high school. We didn't learn this in college. I'm here to tell you right now, there are many attorneys who are purportedly learned in law that don't have a clue about any of this. This is taught to the best of the best of the best, ladies and gentlemen. This information being disseminated to you was brought to me by a bunch of very intelligent intellectuals far beyond my time. Okay, far before me. And I just put the puzzle pieces together. The more that everybody communicates with me, the more information I get. I have people on a daily basis that send me emails of all this information. We're talking about 10 lifetimes of information that you couldn't read in a single lifetime. And I go through using keyword searches to find the pertinent, relevant information to put the pieces of the puzzle together. And I use what people have discovered before my time. Most of this information that's being disseminated to you was discovered by other people before the advent of technology of the internet. Could you imagine how many books they would have had to go read? Or what kind of organizations they would have had to have been a part of in order to put this together? This is huge. This is monumental. It's about remaining in honor or falling into dishonor. It's about understanding the venue, the revenue or revenue that you have been cast into under Article 1, Section 8, military tribunals. It's about understanding the fictitious monetary system. that you are the benefactor, the beneficiary, the fiduciary trustee for this for the Cesta Que Vi entity that was created. Okay, the trust of the United States. The full faith and credit of the United States is what? We the people of the nation. How can I affirm that? 73rd Congress, First Session, Volume 77, Part 1, 1,176 pages. Go read it. It tells you the new money will be backed by the people of the nation. We're the creditors. And people get confused. Well, the bank sent me something saying they're the creditor. In maritime admiralty law of merchant, there is nothing that says they cannot lie. Remember, it's all predicated on presumption and assumption. So if they're presuming and assuming to be the creditor, what is your duty and job? What is your obligation? Your obligation is to show otherwise. Or allow them to be the creditor and come in as surety and say, hey, yeah, I'll go ahead and satisfy anything that needs to be satisfied. I'll take care of that. But I'm going to be substituted and put in the shoes of the creditor, inheriting all the rights, titles, and interest of the creditor, because at the end of the day, you are in fact the creditor. Okay? And that debt, that liability that's sitting on the public side of the ledger needs to be transferred through your exemption, through your pass-through account, to be on the asset side of the ledger so you can debit it properly. Notice that the Postal Service is involved in this. Okay? I learned this some years back. I was in Kearney, Nebraska. I was corresponding with the ladies and the agents there and had a pretty good rapport back then with them. I don't know if some of those employees are still there or not. Sometimes they move, sometimes they quit, sometimes they're transferred elsewhere. But I was standing there one day and a guy came in with a briefcase, and I noticed that he was in uniform, and his uniform was very clear that he was a sheriff's deputy, but more than a sheriff's deputy. See, at the time I didn't realize what capacity he was operating in. See, because he could operate as a peace officer, he could operate as a deputy sheriff, Leo, law enforcement officer, policy enforcer, right? And I said, well, what's the deputy sheriff doing here? And she goes, he's not the deputy sheriff, he's the bailiff. And I was like, what? Yeah, he's the bailiff. Now, I was confused at that time because I wasn't very learned in my studies, just as of yet, right? And she said, yeah, he's not the deputy sheriff, he's the bailiff. Well, he is a deputy sheriff. He fills multiple capacities. He fills multiple roles. Okay? And he's the bailiff. The bailiff. All right? Bailey, bailor, bailiff relationship, right? And I said, well, what's he doing here? And she goes, oh, I hate it when he comes over here. And I go, why is that? Now, I'm talking to one of the leads at the United States Postal Service. All right? I'm talking to what they call is the postal manager, okay? And I said, why do you hate it when he comes here? And she goes, oh, I got to go through all these documents and I got to sign off on all these documents. I go, well, what kind of documents are you talking about? And she goes, things like warrants, foreclosures, mortgages. Well, why would the postmaster have to sign off on all these warrants and mortgages and foreclosures? Because they're all securities. It's all negotiable instruments, and not a dime or a gallon of gas or a drop of oil or a fucking penny moves without the authorization of the United States Postal Service, because they're administering a bankruptcy. All right? So the Postal Service is involved in this. And when you become really learned, they'll enforce your rights and their policies and procedures for things like mail fraud. But you got to know what you're doing. They don't just do it for everybody. You have to become learned. You have to understand the capacities for which you have to be able to operate within the system. Like I said before, you could be the grantor. You could be the grantee. You could be the trustee. You could be the beneficiary. The choice is really yours. There are times that it's beneficial to be the fiduciary trustee. I'm showing that to you. Why? Because the fiduciary trustee gets paid. The fiduciary trustee gets to give orders. You can also be the entitlement holder. That's on the commercial side of things. An entitlement holder gets to give directives with limited liability as well. So it's all about capacity. Understanding capacity. Now you know why the United States of America is the plaintiff in every federal tax case. They own and run the prison system. Transnational Corporation Observatory, nonprofit organization created by Regis Castellina in October of 1999 in Martinique, France. Sorry, my French is a little fucked. I'm not very good at French, but I believe that's Martinique, France. Maintains a global profile on 10,000 corporations. Everything is being run under the law of merchant or law of mercantile, maritime admiralty law, ladies and gentlemen. Now, if you followed me for a while, you understand there are other venues. There's public and there's private. Okay, we have Article 3, subsection 2 venues. We have Article 3, courts of competent jurisdiction and courts of record. We do have them. They're still there. Why? Because our Republican form of government is guaranteed forever. There is nothing they can do to ever remove the Republic. It is always going to be there. But what they're doing is trying to entice you into coming into the public side. All right? And you're coming into the public side naked, without bond, without insurance. And you can't be in the public naked without insurance. All right? That's your SF 24, 25, 25A. Your SF 273, 274, and 275. Anything they have the power to do, where do you think they got it from? They got it from you. They have no more power than the authority and the author, the source of all power, which is you in the fictitious monetary system. The government derives its source of power from who? We the people, in the consent of the governed. So anything they are doing, where did they get the ability to do it? You. You have the power to draft SF 24, 25, and 25A bonds. You have the power to demand that they produce the bonds, because if they don't have the bonds and they don't have the original charging instrument, there's no case. They're looking for you to volunteer. Everything is being run under the law of merchant under Uniform Commercial Code 1-103 because they're private, for-profit, ad hoc corporations masquerading around as government, negotiating negotiable instruments while administering a bankruptcy, trying to get credit because they're under Chapter 11 and they're insolvent. They need your participation and credit. Sections 1775.04 of Title 17 Corporations, Partnerships of the Ohio Revised Code says rules of law and equity, including the law of merchant, to govern. That's UCC 1-103. In the 80s, all states adopted a form of the Uniform Commercial Code. It's international, ladies and gentlemen. I can file a UCC in Bangkok. I can file a UCC in Switzerland. I can file a UCC in China. I can file a UCC in Australia. Okay? The Uniform Commercial Code, when you're filing things, you're filing into a commercial chamber. That's the commercial chambers. When you're filing with the Secretary of State into the UCC, or utilizing the UCC, okay, you're filing into a commercial chamber that is internationally recognized. And it is strictly for commercial business and putting levies and liens and securing contracts and obligations. Okay? UCC 1-103 is quoted in the Administrative Manual. Remember, the Administrative Procedures Act. Everything is being operated under the executive branch. What is the executive branch, ladies and gentlemen? Commerce. The executive branch is commerce. And under the executive branch is the administrative manuals for how to proceed in commerce of the Internal Revenue Service, put out by CCH, and says that the law of merchant governs all sections in the Internal Revenue Code, the IRM Manual, the Internal Revenue Manual, or the Internal Revenue Code, otherwise known as the IRC. You can also refer to Title 26 of the United States Code. Okay? Based on the above information, it looks like GSA and GAO are heavily involved in the accounting aspect of the prison system, which explains why they are supplying all the bond forms respecting the bid performance and payment bond. When your dishonor is sold within the United States, it has a 6-digit accounting number and is called a cardinal number. When it is sold at the international level, it goes ordnance or military and uses a 9-digit account number. Okay, remember that everything that they do pretty much involves 9-digit numbers. Okay, when you get a tax identification number, that's a 9-digit number. You get an EIN, that's a 9-digit number. You get an international tax identification number, that's a 9-digit number. You get a foreign grantor trust number, that's a 9-digit number. Okay, the registered label 200 private mail matter for registered mail, guess what? That's a 9-digit number as well. This is where the AutoTrice and QSIP come in. AutoTrice is the automated forensic trace investigation system and was designed in Russia, Federal Center of Forensic Science, using a graphical toolkit that was developed at Automation Design and Solution, Inc. For other software products, AutoTrice is copyrighted and licensed to AD&S in the United States of America and other countries of America. This program is used as a jail management system for inmate tracking. This system also has a law enforcement module and a court management module for courtroom accounting. Every Metropolitan Police Department and federal police have this system installed in their vehicles and is referred to as the Criminal Justice Tracking System. Okay, this is where the DMV and the AAMVA nonprofit organization go into cooperative agreement with the governor and the attorney general and the secretary of state to cooperate together and split up the dividends and derivatives of all these penal sums and penal bonds they use by tracking all this stuff, okay? And so when you sign up with the DMV, guess what? They sell your private intellectual property and information without full disclosure to 148 different nations through Interpol and over 3,000 counties throughout the United States and all and every law enforcement agency out there, from the FBI to ATF, DEA, CIA, NSA. They sell it all. And the thing is, they never told you that they were going to market your private intellectual property and they were going to sell it for profit and gain. They failed to disclose that to you. You're doing owing because they created that account and that account belongs to you. And they've been siphoning off the profits and the proceeds from selling your private intellectual property. Okay? Ignite Inc. designed the software that is used in the AutoTrice and is located at 1291 East Hillsdale Boulevard, Suite 211, Foster City, California, 94404. Isn't that funny? It's always Silicon Valley finds their fingers in this shit, right? United States of America, 650-655-3700, or call toll-free 1-8666-XML SOAP. QSIP is the trademark for the system that uniquely identifies securities and other instruments of general interest. The name QSIP is derived from the ABA Committee on Uniform Security Identification Procedures. The QSIP agency is the organization with the ABA, American Bankers Association. Okay? Now, later on, we're going to come into another ABA, and that is not going to be the American Bankers Association, so you really need to pay attention to what I'm saying here, because these abbreviations and acronyms They have different meanings, even though they look the same. Dissimilar things should not be joined, and similar is not same. So there's different abbreviations, and this is why I highly frown upon people using abbreviations for anything or acronyms for anything. Always spell out your intent. Always. Don't abbreviate shit. Because remember, in Article 1, Section 8 venues, they are always allowed to presume and assume whatever the fuck they want. Okay? So in order to keep them from being able to presume and assume, we need to be explicitly detailed, crystal clear. No abbreviations, no acronyms. We need to be Nat's ass specific. All right? So American Bankers Association, which is charged with the responsibilities of developing, enhancing, and maintaining the system and policies necessary for uniform securities identification. QSIP is the trademark of Standard & Poor's, okay, which operates under a license agreement with the ABA, the American Bankers Association, and is located at 55 Water Street. Notice how, they're always operating in Maritime Admiralty, and most of the street addresses that you're going to find are going to assimilate or be directly connected to waters or passageways. Something within their address is always dealing with water, showing you that they're dealing in the Sea of Commerce under Maritime Admiralty law. So it's located at 55 Water Street, 47th floor, New York, 10041. Interestedly, this is the same address of the DTC, Depository Trust Corporation. They're all in one big building, ladies and gentlemen. The American Bankers Association and the Depository Trust Corporation are all in the same damn building, all right? Which is the clearinghouse for all goods, commodities. Your precious valued time is a commodity, ladies and gentlemen. Your services, your contracts are goods. And your contracts that you entered into and the things that you affix your signature to are, in fact, securities. It is also called or referred to as the EMCC, the MSCC, the NSCC, or the DTCC, the GSCC, or the GCN, the Global Clearing Network, and DCC and S, Defined Contribution Clearance and Settlement. These are all the clearinghouses for all shares and stocks sold through the CCA and the Payne-Weber Group, aka the United States of America. Okay? This United States of America differs from the Federalist Papers, Article 1, Section 1. How can we say that to be affirmative and factual? Because under the Federalist Papers, Article 1, Section 1, the T on the word the has to be capitalized. The United States of America ends with a period and has quotation marks at both ends. Okay? So this is different. You see how they create all these entities? They look the same, they sound the same, but they're not the same. Okay? These are all different entities. And they do this because it creates confusion. I've got a recording of a city board council meeting where they're putting together the city board together. And on one end, they have the public, the city board of, let's call it Watusi. And then they go into private session and they create a nonprofit organization called the city board of Watusi. Now, when people are in these public meetings, well, which entity are these public officials sitting on? Are they in their private PMA? Are they in their private non-taxable 501c3 organization called the City of Watusi? Because, see, the positions they hold are the same in both organizations at the recommendation of the attorney so as not to cause confusion. No, it's really to hide what's really going on. Okay? So they have the City of Watusi that's a public entity. And then they have the City of Watusi, which is a private entity, and the chairman is the same on both entities, and the directors and the board that supervises it are in the same position in both of the entities, but they are two separate entities. So when they publish things, people think it's for their benefit and it's for their good, but in reality, they're doing it in a private PMA. that's a non-taxable organization. So when you ask them for their 990, they give you the private PMA 990 that shows they're a private nonprofit organization. But in reality, what they're actually doing is they're operating under a DUNS number. So they're a private for-profit corporation negotiating negotiable instruments under the UCC. And they're using their private PMA as a pass-through account. Yeah, fuck around with me and find out. They created me. I am a direct product of these evildoers, wrongdoers, who were hell-bent on deceiving people. And as soon as I started to see it, boy, I'm like a bloodhound in heat. I ain't gonna fucking quit. I'm gonna get some of that tail. It's gonna happen. All right? I want that ass. I finally understand where the United States of America is located and who they are and why in the blue book put out by the ABA, here's the difference. Here we go. American Bar Association. Before we were talking about ABA as being the American Bank Association. Now we're talking about the blue book, the key of knowledge. Woe unto you lawyers, for you hinder those who seek to enter in, but ye yourself do not enter. And those who seek the knowledge, right? You have the knowledge and you yourself forbid anybody else from utilizing it. The blue book, if you go look at the blue book, it's got a key on it. That's symbolism for the key of knowledge, which was told to them by Jesus the Christ himself. Put out by the American Bar Association, they are referred to as a foreign country. They're foreign. Okay, when they take that oath, they're foreign to you. All banks are foreign. All corporations are foreign to you. QSIP also identifies the issuer. I am the original source value issue of all issues. Issuer of all issue. Issue is a note, draft, bill of exchange, letter of credit, irrevocable letter of credit, banker's acceptance, trade acceptance, bond, or security. I am the original source value issuer of all issue. All credit must return to its source. You come from the dirt, and you will return to the dirt. That's your body, not you in the spiritual aspect, but you are made from the mud of the earth, and you will return to the earth. Because the source of credit, the earth, for your body, will reclaim its credit. It's nature and nature's God. They're just replicating exactly what already has been existent since the beginning of time, and they're using it to their benefit. Using false and misleading and deceptive trade practices and a false conveyance of language to get you to believe that you are a thing in rem and stand in as the debtor instead of coming forward in your proper capacity as surety or grantor or benefactor or beneficiary or fiduciary trustee. All right? Like I said, I used to want to tear this system apart. Now I find myself in a position where I see the need for it. And at the same time, it's caused me to become a better man, to ascend of the mind. It's forced me to learn things that I otherwise wouldn't have learned. I'd still be a Neanderthal putting two sticks together out in the construction field had it not been for them taking their interest in me. And the Heavenly Father putting it on my heart that something is wrong and that I owe him a duty. That I owe the Heavenly Father a duty to investigate and to figure it out and to be about his good works, which is why I'm sharing this information freely. That's why I do it. Some of my mentors heavily frown upon what I'm teaching you guys right now. They do not like what I'm doing. They ask me to stop on a daily basis. Please stop. Please don't do this anymore. Please, you don't understand what you're doing. Stop. This isn't for everybody. You're putting yourself in danger. I don't care. I'm ready to go home. I've been waiting to go home for a long time now. I'm ready to go home. This place is hell to me. I'm ready to go. And for evil to prevail, it requires good men to stand around and be silent and do nothing, and I am not that. I'm a different caliper. I'm a different breed. You can't teach people to be like this. You can't ingrain them to be like this. You can't break them down and make them like this. You either are or you are not. In some aspects, people say it's selfless. Oh, it's such a selfless act. No, it's selfish. I can assure you that even in the most selfless act, it's selfish. I do this because I want to see a better today, not tomorrow, but today. I want to see his people rise once again and take the reins. Power corrupts, absolute power corrupts absolutely. I think it's time we take the power back. The power they've usurped that wasn't otherwise delegated to them, ladies and gentlemen, and the only motherfucking thing they care about is ones and zeros on a fucking ledger. That's it. That's all they care about. Like I said, slavery wasn't abolished. They just renamed it, redesigned it a little bit, turned it into a prison industrial privatization complex using the law of mercantile and law of merchant under maritime admiralty law, running two venues concurrent because you have the public and the private side running simultaneously. And they try to keep this knowledge from you. You start talking to a lawyer who's been in the field for 30 years about stuff like this, and he'll tell you you're fucking crazy. The people that learn this information that I'm sharing with you at the highest level, you never even get to meet. You subject something, you insert something into the account number, the case file jacket, the docket number that's above their pay grade, and they're told if they see certain activity that's peculiar, less than often seen, they are to report it up the chain of command because it's above their fucking pay grade. They're on a need-to-know basis because it's all militarized. They're all compartmentalized. It's only the people at the top, the upper echelons, the CEOs, the CFOs, the chief justices, the governors, the attorney generals, the Office of Inspector Generals. These are the people that know. They know what's going on. They're in the know. And so when you comprehend capacities and how they work and how they operate, and you know who you are, now you can make your claim while remaining in honor. And this system, albeit as corrupt as it is, there is within this system a structural framework that must be abided by or it all collapses. And do you think those people at the top of the hog want it to collapse? Absolutely not. So when you know who you are and you understand what you're doing, they will absolutely honor it. Without question, equivocally, hands down. They might not tell you why they're honoring it. They might not give you the glorification and gratification of responding to you in a physical correspondence you could share with the world. But you'll notice that what should be done shall be done and will be done. Their silence being acquiescence. You might notice it in small, intricate ways. You might notice that you get pulled over and they say, oh, sorry, I made a mistake. I got another call. Have a good day. It's your lucky day. Because the low rent agents and agency are trained that way. If you see something that pops up on the computer, don't ever divulge that information to the ones that you're interacting with. Just tell them you've got to go. Just tell them that you've got an emergency call and it's their lucky day. And then what do they tell the low rent agents and agency with an IQ of 70 that aren't very intuitive and aren't very experienced and don't further study to excel in their craft? Oh, well, they're on an FBI watch list. They're on a CIA watch list. The NSA is taking interest in them. They're being looked at for being federally indicted. And so the low rent, low IQ people just go, oh, okay. Well, our chain of command told us that you're being watched. So that's why. It's not because you know more than the rest of us or that you're above the law or anything. It's because sooner or later, you're going to be scooped up. I've literally had agents and agency tell me that. I laugh. I think it's funny. Because I know exactly what's going on. They're protecting at the highest level the public trust. They're protecting my interests. They're protecting the land of milk and honey. As above, so below. Right here on this earth. All right. enough about me. Let's move on. QSIPs also identify the issuer. I am the original source value issuer of all issue. Whether you realize it or not, they're hypothecating the credit into existence using your good name and your credit worthiness because you are the fucking creditor. They all work for insolvent, defunct, de facto organizations. Okay? They need you, baby. They need you. Most of all, they need you to be willfully ignorant because everything I'm talking about, they have published somewhere. You can find it. That's one of the rules to the game. They have to publish it. They don't have to tell you where they published it, but they have to publish it, ladies and gentlemen. So the QSIP also identifies the issuer of securities and other financial instruments with a standard 9-character framework and disseminating this information to the financial marketplace. All right? The Federal Reserve Form 2049 or the Money Net Daily Log Transaction Report 120 shows the source of the funds, the destination of the funds, and where the funds were sent to. That's why the bank will never show you that. But most of all, the reason that they're not corresponding with you and they're not doing what you're telling them to fucking do is because they're presuming and assuming you to be the debtor and you're responding to them after they sent you a letter saying, "Dear debtor, you're in default. Dear debtor, we're trying to work with you. Dear debtor." And you're responding back to them, "I want this, I want that, I want this." Well, you're not in the right capacity to making demands on the presumed and assumed creditor. Creditors don't answer to debtors. You ready for it? I'm going to drop you the jewel. The capacity of surety is the one that gets to make demands on the principal creditor or the presumed principal creditor, which is the surety's principal. And the surety gets to say, "I demand you produce the Money Net Daily Log Transaction Report 120. I demand that you produce XYZ. I demand that you produce Federal Reserve Form 1049. I demand that you produce IRS Form 1099, 1099A, 1099B, 1099C, 1099 OID, 1099 miscellaneous," right? The surety, the capacity. I, Derek, am writing you in the capacity of surety, and I am compelling and commanding you to do XYZ, and if you don't, I will no longer stand in as surety. That's otherwise identified as the right of rescission. The right of rescission. The right to take your property back. Because who's the debtor? Who's the one that's primarily liable? Who carries an active degree of fault for liability? The United States. That all caps ens legis entity belongs to the United States, is a United States citizen, is a resident of the United States, and is in fact a debtor. Don't believe me? The first birth certificate, the actual instrument produced, which is an application, was sent to the DTCC in Washington, D.C., and that is where it is warehoused. That is where it's at. It is a United States citizen. All those birth certificates you got after the fact are nothing more than copies. Certified copies. The actual ens legis entity is a resident of the District of Columbia. Can be found in Article 1, Section 8, Clause 17, the territory and the venue of the United States, which is the debtor. I have form from QSIP called a private placement equity. Write that down. Private placement equity. You see, they expect you to give equity, but they don't get equity because they never gave you equity. You were never fully informed. They denied you your right to be availed. They denied you due process of law. But we're not making that argument. I just want you to understand how strong of a foundation you stand upon when demanding this information. You are with clean hands. They are not. You have a right to be availed. Okay? And they're violating that right. And you have a right to restoration. Hold on. Gotta change over the power source here. You have a right to restoration. Remedy are rights. Remedies are rights. Rights are property. Property are rights. And property is remedy. Without one, you can't have the other. All right? Life, liberty, the pursuit of happiness, and the right of enjoyment of property. And comprehending capacities. It's such a beautiful thing when you understand the difference between public and private. Which identifies mutual funds, preferred stock, warrant and rights, rights, titles, and interests, preferred stock versus general stock. We have both in our constructive possession. It's a general intangible. We have both preferred stock and general stock. The preferred stock is the birth certificate you hold, proving that you're the attorney in fact on behalf of the principal, that you're not liable for it, but that you have the right of use of it, and that you're held harmless for any harm, damage, or loss you may cause the estate. That's under the Trading with the Enemy Act, 40 Statute at Large, 411. Go read the entirety of it so you comprehend it. But more specifically, 40 Statute at Large, 411, Section 7E. Anything done or omitted under any rule, regulation, order, or proclamation made by the President of the United States is full acquittance and discharge. That's huge. Every negotiable instrument you sign, 48 Stat 112, you must state your intent. You must state your intent, or they will presume and assume your intent was to be the debtor. Your intent was to operate in the capacity of a debtor, an obligor, a payee. A payor. All right? You must state your intent. How much do you want to bet that QSIP and the DTC are the clearinghouse for all arrest warrants? An arrest warrant, ladies and gentlemen, is nothing more than a financial instrument. It's a check. A warrant is a liability on the public side of the ledger. And they need our exemption to transfer it and balance the ledger and take those credits and convert them into fungible funds on the debit side of the ledger, which is the asset side of the ledger, which belongs to us. They need you to authorize through your exemption to zero balance that account, which brings down the national debt, by the way. Because the national debt, as I expressed earlier in this audio and video, is due and owing to we, the American people, who are the preferred stockholders with special drawing rights, who are backing the full faith and the credit of the United States through our labor and our precious valued time commodity that has been pledged to the IMF, the International Monetary Fund. Warrants are a commercial paper. And all commercial paper has value, whether it be a contract, a bond, a security, it matters not. And you have to go into honor and accept it for value. And compel them and demand of them to use your exemption for post-settlement and set-off. Post-settlement and set-off. There's a difference between set-off and discharge. And they need you to authorize them, being that you are the power of attorney, or the attorney, in fact, having power of attorney on behalf of that debtor ens legis entity, you have all the power to authorize them to use the exemption, the Social Security account for which the credit flows through, to use your exemption for post-settlement and closure. So they can move those credits, which are a liability, on the liability side of the ledger, and move those to the asset side of the ledger, which then become debits that are yours. The asset side of the ledger is yours. The liability side of the ledger is truly yours as well when you understand it. But for simplicity's sake, we'll use that example, which are commercial checks under Article 3 of the UCC. I also have a form called a private placement debt, which identifies the purchase serial bonds, the term bonds, currency, and sinking funds. Now, when you start studying the court system, you will find that every court, from the highest to the lowest, they all have these sinking funds. When you start reading their rules and modus operandi and what the court clerk is responsible for, and the sinking funds, and managing the cage code, and working through the auto trice system and all this stuff that they're in control of, and having a private, separate, distinct bank account, and then you keep reading into the court system, and you'll find that there is what is called the disputed ownership funds. Disputed ownership funds. Okay? Because again, everything is about banking, and as soon as they bring the charges, they've already drawn the credit. They're waiting to see if you're going to go into honor or dishonor, and if you go into honor, well, now the trustee and the beneficiary have to agree on the taxes due and owing before the disputed ownership fund can be distributed to you. And it's going to be distributed to you in the capacity of fiduciary trustee, and you're charged with the duty to make sure it gets to who? The benefactor beneficiary, which as soon as you walk out the door is you. You have the ability to utilize multiple capacities, but you can't simultaneously wear them. It's like putting on a cowboy hat and trying to put on a baseball cap simultaneously. You're going to look awfully fucking doofy. You're going to look awfully fugly. You're going to look strange, and people are going to go, there ain't something quite right about that one. So don't make that mistake. Understand the capacities, what you're doing, why you're utilizing it, when you're doing it, and when to hang up that hat and put on the next hat. So you don't look like Dudley Doofy. All bonds are identified by using QSIP, 9-digit number. I have a 26-page list of bonds, treasury bills, notes, Freddie Mac, Ginnie Mae, Fannie Mae. They are also offering TBAs, which are future contracts on mortgage-backed pools. Remember earlier when I told you when you fall into dishonor, then they go ahead and they sell the bonds. Then those bonds get sold to an investment banker, an investment banking firm, and they turn around and they sell it back to the public, and then they turn into mortgage-backed securities. And all judges sitting on the bench, their retirement, like over 33% of their retirement is heavily invested into mortgage-backed securities. They love it when you're in dishonor. That's why they're all retiring with multi-million-dollar retirement accounts. Because of the dishonor, because we don't understand the system that we've been subjected to. We don't comprehend that they're operating Admiralty Maritime Law under Military Code and Doctrine under War Powers Act, negotiating negotiable instruments, utilizing the UCC, hypothecating our credit into existence, and by our dishonor, we're challenging the national debt instead of saying, hey, we back the full faith and credit of the United States. No problem. I accept for value. Use my exemption for post set-off and closure. I need a full accounting. I just came in as surety and satisfied and settled your obligation that you created. And now I fill the role of creditor. And I'm entitled to the rights, titles, and interest. Never mind the conflict of interest. I'm not here to... Look, I'm only mentioning certain things in the hopes that it might catch somebody who's paying attention and watching and trigger them to think outside the box, Or maybe that's the missing piece they need. I'm not here to create controversy. I'm here to show you how to put your ego to the side and do away with the controversy. I want you to understand what's really going on, so you have to understand it in the full aspect of how it's all works. Okay, that's why I explain the exclusive jurisdiction of equity, concurrent, auxiliary, exclusive, and I show you on the public side, they got war powers, statutes, codes, city ordinances, rules, and regulations, and on the private side, we have grace, forgiveness, mercy, nature's God, God's law, things of that nature, right? I show you equitable by characteristic, and then I show you equitable by nature. Okay, I show you legal by characteristic, and I show you legal by nature. All right, but they're two different separate and distinct jurisdictions. So understand this. What I'm showing you guys this evening, I don't want anybody going in there and arguing, oh, I know this is true. I know this is what you're doing. I know this is how it's going. I have a right to face my accuser. That's all creating controversy. I'm trying to show you essentially what confession and avoidance is. Because it's all banking. It doesn't matter what they charge you up with. Okay, when you finally grasp what I'm speaking to you about, you'll soon realize the credit card contract, the mortgage documents, the utility statements and bills, all this stuff. You're the surety. And you get to come back in and fill the shoes and be substituted as the creditor, which means all rights, titles, and interests the creditor had the right to now comes back to you. All your payments, all your precious value time commodity. They can't give you back your time. Once it's gone, it's gone. You only have so many heartbeats while you're on this earth, okay? And thank God they don't get to determine that in most instances, all right? The Heavenly Father determines when it's your time. But they are usurping power, otherwise not delegated to them, using maritime admiralty and the presumption of a social compact and contract between us all. They have created a trust, a public trust. And somehow the American people have been dubiously duped, and the people, furthermore, of the world, because the banking system is pretty much the same throughout, with the exception of Iran, China, Russia at one point. There were like 9 different countries that had a completely different banking system. But, we had to go to Libya. We came, we saw, we whacked him. That's what old Hillary said. She was awfully boastful about that. And then we went into 9 other countries, and the one that we left standing was Iran. All right? And you have to understand why they did that. Try to get everybody under the same fictitious monetary system. In their religion and their culture in these other countries, they didn't believe in usufruct. They don't believe in interest. It's against their religious beliefs. Usury is against the law in their cultural beliefs and in their spiritual beliefs. Well, that's what this whole system is predicated on. Usury and usufruct. Interest. And it can't exist in any other form, fashion, or way other than at the barrel of a gun, utilizing penal statutes and penal sums and penal bonds that are attached to statutes, codes, city ordinances, rules, and regulations in a fictitious monetary system. Only in a fictitious monetary system can you take something and produce it and then say you need 10 more from whoever you lent it to. See, there's only as much gold as there is gold, so you can't lend it out and say I need 10 more shekels back because I'm going to give you this 1 shekel, because there's only as much as there is in existence, right? But in the fictitious monetary system, we can print endlessly ones and zeros on a ledger, and we can compel and demand in the form of interest and usury that you give us XYZ back, which ultimately creates a system of usury where they're hypothecating your future precious value time commodity for services and goods to be utilized to keep their system afloat. Is it a bad thing? Maybe, maybe not. I see the benefit to it now. I didn't used to enjoy the system. I like it now. I still deal with agents and agency that are rogue from time to time, but that's all right. I have my way of handling them now. So it's not bad. And that's all I'm trying to teach you guys. That's all I'm trying to show you guys. I'm just trying to open up. I'm just trying to plant some seeds to help you grow. So you can get past the 7 stages of denial: anger, resentment, disbelief, being nauseous to your stomach. Just trying to help you overcome that, because that's a tough one to swallow. That's a tough hill to traverse. That's a lot of people get plateaued on that and run around vengeful, spiteful, and angry the rest of their fucking lives, screaming at people, you can't do this, you can't do that, while they're doing it. All while they're doing it right in your face, because you don't understand that you're in dishonor. And so I'm trying to help you guys overcome the dishonor part, the be right-itis part. We don't need to be right. We just need to be in honor. That's all I'm trying to do. That's all I'm promoting. So why I'm explaining it in such depth is because I have a plethora of people, over 18,000 people worldwide, that follow me. And some people comprehend in a different form or fashion. Certain explanations may trigger something in their mind, even though to you it's just benign, rhetorical, and frivolous. And so that's why I do it. Because there is strength in numbers, even though this is an individual journey. There is strength in numbers because it's thought-provoking. And surrounding yourself with people that may or may not be more intelligent than you, but are at least critical thinkers, will help you develop exponentially at an expeditious rate. That's why I do what I do. 15 years ago, it was a very lonely world out there for me. Very lonely. People are strange when you're a stranger. People are even more strange when they think you're a fucking nut. All right? And as the series of political events has unfolded in the last 8 years, all of a sudden, Derek's not so fucking crazy. All of a sudden, Derek might not be the fucking nut we pegged him to be. There are a lot of people that watch me quietly from afar. There are a lot of public officials that watch me quietly. I've been reached out to by senators and congressmen before. I've been asked to personally meet with them and speak to them about the things that I'm discovering. Now, whether or not that's beneficial in any way, shape, or form, I don't know. I don't know. Maybe it's a test. Who knows? I'll tell you this much. A lot of people didn't realize that the whole country was created by Freemasonry. All right? Or the illusion of the country, which is a private for-profit corporation. And that every governor answers to the most worshipful, most wonderful Grand Master Mason. In all 50 states, there is a most wonderful, most worshipful Grand Master Mason. Go look him up. Go look him up. The most wonderful, most worshipful Grand Master Mason. And they sit above all 50 state governors. And the governor is the president, who has a small military force known as the National Guard and the state police, who is the president of a subsidiary corporation of the parent corporation known as the United States. Title 28, 3002, 15A, B, and C. So the state of is a fiction and is wholly separate and single and divided from Arizona. The state of Arizona is not Arizona. They are two very distinct, very separate things. And it's imperative that people understand that, comprehend that, can see that. So again, don't take my word for it, but go look it up. The most wonderful, worshipful Grand Master Mason. There is one above every governor in every state. If you don't think they're running the shit show, you are sadly mistaken. And I've been invited to the Knights of Malta. I've been invited to the Masons. I've been invited purportedly by people that supposedly are part of the Illuminati. I've been invited to a lot of different things because I'm very vocal. But I have this problem. I don't trust anybody. And I especially don't trust any societies. Right? So take it for what it's worth. You know, these people that came to me, I was once reached out to by purportedly a retired CIA agent. Now, there were a couple 65-year-old lads around me, and I always keep my phone on speakerphone. And when this guy called, it gave them the goosebumps and the chills so bad, they both departed. They took off. They left. I called them after the phone call. So where'd you guys go? And one old gentleman who was in his 80s goes, let me tell you something, son. I've been around the block a lot. I was in NAM. I've been involved with all kinds of things with the government, good, bad, and otherwise. I'm telling you right now, there ain't nobody that ever retires from the CIA. And that was enough to give me the heebie-jeebies. And I just as soon not be around if you're going to continue talking to a guy like that, because there ain't nobody that retires from those outfits. I'm going to tell you that right now. And he was nervous about it, scared about it. Now, whether or not the guy actually worked for the CIA, I didn't see no credentials. I don't know. Maybe he was, maybe he wasn't. Who knows? All right, but one thing we do know is true is that we study and we show ourselves approved and we start to learn how this system functions and operates. All right? Life becomes a lot better. When we understand the nature of the beast and we can properly assert ourselves timely and stay in honor, life is but a dream. That's all I'm trying to do is help you guys out, help you see it for what it is. You know, you got all these patriots out there that think they're part of a country. And in reality, they've subjected themselves to being a subject serf, and they've filled the role of being the debtor, obligor, the liable party, unwittingly and unknowingly. But their patriotism won't allow them to remove the veil and the cloak and the subterfuge from their eyes to actually see what's transpiring. And for those people, I am filled with great sorrow. But I also am not going to sit here and piss on a flower all day and hope it fucking grows leaves. All right? I'm not going to waste my time trying to convince anybody of anything. It's your duty and responsibility to go investigate this further. Don't take what I say as the gospel from the Heavenly Father himself. Go look at it and research it for yourself. You can only plant the seeds and point you in the right direction. But I can tell you this right now, in 15 years of research, this information I'm sharing with you right now is spot on. Spot on. But if you don't know it yourself and you don't understand how it works, they'll ask you a couple simple questions and to the hooskow you'll go. Or maybe they'll ignore you and you just don't know how to respond. People go, oh, well, they know they're not supposed to be doing this, but they did it anyway. You know what you have to do when they trespass on you? You have to bring suit. You have to bring suit. Well, I shouldn't have to. Okay, go ahead, be right about being wrong. Go ahead and tell me how you shouldn't have to do this and you shouldn't have to do that. Da, 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 da. Go ahead and argue yourself right about being wrong. Just like you can't prove a negative, you can't argue yourself right about being wrong. But people try every day. Fuck, I speak from experience. I used to be one of those half-wits. I used to do that shit. That's why I speak with such conviction now. All bonds are identified by using a CUSIP 9-digit number. I have a 26-page list with bonds, treasury bills, notes, Freddie Mae, Ginnie Mae, Fannie Mae. They are also offering TBAs, which are future contracts and mortgage-backed pools, working with the MBSCC, the CUSIP Service Bureau Development, a specialized numbering scheme, TBA, the Bond Market Association. TBA is the Bond Market Association. Okay? And the MBSCC and the CUSIP Bureau Service Development is working with the Bond Market Association. Mortgage-backed securities. Mortgage-backed securities is ownership position in a group or pool or mortgage loans. Okay? When they put your butt in prison because you went into dishonor and you didn't just, tell them to use your exemption for post set-off and settlement, to take the credits from the liability side and move them over to the asset side of the ledger so you could debit them and use them as fungible funds, right? Then it eventually becomes mortgage-backed securities that are pulled together, and there are groups out there like attorneys, lawyers, and judges that have their retirement heavily seated in mortgage-backed securities. It is bonds in which interest and principal received from this pool or of mortgage loans are passed through to the bond holders. TBA QSIPs incorporated within the number itself a securities mortgage type, Ginnie Mae, Fannie Mae, Freddie Mae, coupon, maturity, and settlement month for financial instruments activity traded on an international basis, which are either underwritten debt issues or domiciled equities outside the United States and Canada. The financial instruments will be identified by a CINS QSIP International Number System. All right, that's CINS, QSIP International Number System. The CINS number was developed in 1988 by Standard & Poor's and Telkers USA in response to the North American securities industry need for 9-character identifiers for international financial instruments. CINS, CINS, numbers appear in the International Securities Identification Directory, ISID, plus services, which is co-produced by Standard & Poor's and Telkers USA. To show how massive this system is, ISID Plus contains over 500,000 global financial instruments and cross-references all major national numbering systems. ISID Plus has been designed to minimize the impact on back-office systems and operations, while facilitating cross-border communications among global custodians, depositories, banks, securities, organizations, and exchanges. CINS numbers employ the same issuer 6 characters, issue 2 characters, and check digit concept espoused by the QSIP numbering system. The first position of a CINS code is always represented by an alpha character, signifying the issuer's country code, domicile, or geographic region. The National Association of Insurance Commissioners, NAIC, remember I told you, what are the 4 elements in this fictitious monetary system, in this fictitious monetary environment? Securities, bonds, excise taxes, and insurance. What do we got here? The National Association of Insurance, NAIC, in October 1988 mandated the use by issuers of a uniform private placement number, PPNN, okay? Private placement number, PPNN, to identify investments in their annual statement filed with the state regulatory authorities, Standard & Poor's, okay? What is Standard & Poor's? Standard & Poor's, and I got to think about this for a second because I want to be able to articulate it properly. Standard & Poor's is directly linked to the Lloyd's of London, which is the largest insurance and bank company worldwide that insures all 3,000 plus counties and cities throughout the United States of America. The Lloyd's of London is where all the gold is, all right? QSIP Services was selected by the NAIC to create, assign, and administer the PPNN system primarily for the insurance industry. At the international level, there is EPIM, the European Pre-Insurance Messaging, which is a central messaging hub linking the parties involved in the issuance of European commercial paper, ECP, including banks, cooperative effort by Euroclear, Clearstream International, and DTCC, Omega LLC, a joint venture company owned equally by the Depository Trust and Clearing Corporation, DTCC, and Thomson Financial is the leading of the complete global trading management services, a unique partnership between the securities industry leading utility and the commercial sector. Omega is industry-backed and market-oriented through its integrated suite of Intelligent Trade Management Solution, SM. I have the article of incorporation of the Association of National Numbering Agencies, or ANA. Okay, ANA is another acronym that you need to become familiar with. So we have the DTC, the ECP, the PPNN, the NAIC, and now we have ANA. The registered office is located and established at 6th Avenue de Schuylkill, 1140, Brussels, Belgium. The object of ANA is to maintain and promote the standards of International Standard ISO 6166 as amended from time to time thereafter, the standard. I bet that this standard, number 6166, is the number of man, and his number is 666, and is talked about in Revelations 13 and 18, and whose purpose under Article 3 is to man and his is to carry out any commercial, financial, or civil transaction directly or indirectly related to the objects of ANA. Under Article 5, ANA has unlimited capital through BIS. This is very important. The BIS is Bank of International Settlements. All right? CCA, ALEC, Wackhut, Cornell Corrections, Reason Foundation, Dillon Reed Venture Capital, SG Warburg, UBS Warburg, Warburg Dillon Reed, and the Payne Weber Group. Under Article 29, ANA has a list of all the public fines, shares, stocks, bonds, and other securities composing ANA's portfolio. I think ANA is owned by the Order of Jesuits out of Rome, Italy, which owns and controls all prisons, penal institutions, and banks. ANA also assigns the ISIN, International Securities Identification Numbers, the first category, equities, debt instruments, rights, options, futures, others. The second character, group, within category, ergo, equities into shares, preferred shares, etc. The third to sixth character attributes for further description and grouping. Why is privatizing prisons so appealing to the federal, state, and local governments? As The Nation put it, the selling point was simple. Private companies could build and run prisons cheaper than the government's unfettered American capitalism would produce a better fetter, saving cash-strapped states millions of dollars each year while simultaneously generating huge profits. Okay? So they're not having to take care of the people anymore. Remember, to our peace and our posterity, to the general welfare of the public, the people, right? Well, by putting everybody in prison camps, because remember, the only way that you can be subject to peonage is if you've been found guilty of a crime, right? And so they've privatized the prison system to further engage in slavery, and then they create all these statutes, codes, city ordinances, rules, and regulations attached to penal sums, get you to go in there and be combative, and a belligerent enemy combatant that is directly going against the public debt and violating public policy and failing to use your exemption for post-settlement and set-off, accepting the value of the charges, and then they get to cast you into peonage, which is forced labor, because you're presumed and assumed in Article 1, Section 8 military tribunal to be an enemy, belligerent combatant, and a criminal. Then they get to sell off the credits that they have authenticated into existence through the performance bond, bid bond, warehouse bond, prison bond, SF 24, 25, 25A, and the SF 273, 274, and 275 that ensures or assures that the United States federal government won't be caused harm, damage, and loss. The nation explains this miracle would be accomplished. Private prisons receive a guaranteed per diem for each fee for each prisoner, regardless of the actual cost. Each dime they don't spend on food or medical care for prisoners or on wages and training for the guards is a dime they get to pocket. Most guards in public prisons belong to the LEOU, L-E-O-U, Law Enforcement Officer Union, which is a part of the American Federation of State, County, and Municipal Employees, AFSCME. Remember how I told you that these people that are alleging to be police officers are really foreign agents and actors and a foreign standing military on our land, on our soil, trying to usurp power otherwise not delegated to them, utilizing statute, code, city ordinances, rules, and regulations to generate securities on the side of the road, okay, as motor vehicle code enforcement officers, all right? Now, they have many different capacities they can operate in. Sometimes they'll be standing there as a civil servant standby. That's when they're operating as a peace officer, okay? And statutorily, that can be proven. It is written in their own statutes that there are times, for example, when they show up with the CASA or CPS, they're there as civil servant standbys to maintain the peace. They're operating in a different capacity. In the capacity where they're issuing citations, which are really securities, obligations, contracts on the side of the road for benign, frivolous bullshit, they're operating as a motor vehicle code enforcement officer, utilizing the statutes and codes to create negotiable instruments. All right, and they're operating underneath the AFSCME as a LEO, a law enforcement officer, part of a law enforcement officer union. They are policy enforcers at that point, okay? And they're tied directly to the American Federation of State, County, and Municipal Corporations. Municipal corporations are your cities, your townships, okay? Those are municipal corporations. They have a private DUNS number, okay? They have an EIN number. They have a tax identification number, and they go into private contractual agreement with the AFSCME and the LEOU, Law Enforcement Office Union, and they hire these jackboot thugs to issue and enforce statutes, codes, city ordinances, rules, and regulations that are attached directly to penal bonds that the American legislative corporation group have created. All right? To do what? Generate negotiable instruments so they can negotiate them on the international secondary stock exchange due to our commercial dishonor by challenging the public debt, by falling into dishonor and not accepting the charges for value, using our exemption to post set off and closure of the account. I have a question for you. Why aren't we as principals, okay, remember we're the principals, on the private side of the accounting cycle, the general accounting principles, using our exemption priority to discharge all this public debt under the Uniform Exemption Act, Section 3, exempt means protected, and answer is we are all double-minded and do not know who we are in the commercial setting. This is why it's not being accomplished. Because when you go to the public fool system, you're indoctrinated and ingrained to believe and think a certain way. You stop asking who, what, where, when, why, and how, and you start making statements, and the statements are fucking dangerous because you draw conclusions. And once you draw a conclusion, you're dead in the water. It's over. Game over. You're done. Until you can get out of your own way and realize that your 6 best friends are who, what, where, when, how, and why, and avoid making statements, aside from the fact that use my exemption for post-settlement and closure, right? Every individual in prison is in there because of commercial dishonor. It's all under maritime admiralty, law of mercantile, law of merchant, Article 1, Section 8, military fucking tribunals, guys. I don't know probably but a handful of my mentors that have ever actually been in a court of competent jurisdiction and a court of record according to Article 3. I believe myself to have been in that situation twice, but I had to really work my ass off to get there. And there is no physical evidence or documentary evidence or video evidence or footage that I could share with you to prove that. It was just the way the proceedings were conducted and the way that the venue changed that leads me to believe that at 2 times in my life, I've been in an Article 3 subsection 2 venue, a court of competent jurisdiction and a court of record. All right. And again, there's physical evidence of one, the exoneration and acquittance, which is in fact a check. A person who has doubts is thinking about 2 different things at the same time, and he can't make up his mind about anything. Or, as the King James Version says, a double-minded man is unstable in all his ways. James 1:8, let us reign and claim our honor and status as the principal with primary responsibilities and obligations for discharge on the public and payment on the private. Through our exemption as principal, we can use these standard forms 24 bid bond, that's SF 24 GSA bonds, 24 bid bond, SF performance bonds, standard form 25, and payment bonds, standard form 25A, issued by GSA under the Comptroller General to discharge any debt. Bonds, bid bonds are usually purchased by brokerage houses and insurance companies. By legal definition, all of your federal and state statutes are bonds or obligations, okay? Directly tied to a penal sum of record and are represented in the courtroom by a recognizance bond, which is a bond of record or obligation for the payment of a debt. And that's where you go in and you accept it for what it is, for value, and you demand they use your exemption for post set-off and settlement and closure. Post set-off and closure. A condensed version of what is going on is that the CCA as a corporation creates or issues stock certificates based on prison population, goods or chattel as they are called in commercial law. The underwriter, which is you, is the one who buys the stock from the issuer, the CCA, with intent to resell it to the public or an entity or person, which is usually an investment banker. The investment banker purchases all or part of the shares of the stock for resale to the public in the form of newly issued investment securities. So this is the reissuance, all right? The reissuance of securities from the old bonds based on the bond issued by the GSA. The bid bond is then indemnified by a surety company through performance and payment bonds. The bid, performance, and payment bond are then underwritten by the banks as investment securities for resale to the public. The institutional holders who own most of the shares are FMR, Fidelity Management and Research Corporation. They own 3,084,024 shares. This was back in 2010, by the way, at a value of 109 million plus. Legg Mason Inc. They own 1,235,000 plus shares at a value of 43 million. Barclays Bank PIC. This is again back from 2010. 1,041,000 shares at an approximate value of 37 million. There are 7 more corporations owning various amounts of shares at varying dollar values. These can be viewed by going to http://finance.yahoo.com/q/hm?s=CXW, which is the ticker. The CXW is the ticker for them. The top insider and Rule 144 holders are Russell Joseph V, 64,000 shares as of the the 2nd of May of '03. Ferguson and John D., 40,000 shares, 2nd of May of '03. Quallan J. Michael, 28,000 shares, 10 September of '02. Turner Jimmy, 13,000 shares, plus 23rd of May of '03. And Horner John R., 5,000 plus shares, 29 June of '04. As you can see by the above information, this system permeates every fabric of our society. As you can see by the above information, this system permeates every fabric of our society. This treatise represents about 40 hours of brainstorming, not to mention the guy that put this together. I think 6 or 7 of his brothers were all judges. Some of them were lower state court judges and others were federal judges. So he put this together not in 40 hours. It was 40 years of his life plus the 40 hours he sat there and thought about it all and put it all together for you guys. Current global terrorism is being funded by the prison system and the State Retirement Fund. Go to www.divestterror.org. This is a 115-page report on terrorism investment of all 50 states. They're all investing in this, guys. And we're funding it through our ignorance. By going into dishonor, we're giving them the ability to generate domestic terrorism, genocide, democide, all that stuff. We're funding it due to our ignorance. Go to a search engine and type in U.S. courts. Go to court links and click which shows a map of the circuit courts. Click 7th Circuit. A list of 7th and 8th Circuit courts will appear. Click on Illinois Northern District Court, then click on the clerk's office, then go to Administrative Services, then to Financial Department. You will see Criminal Justice Act, post-judgment interest rates. Post-judgment interest rates. All right? They're already collecting an interest, presuming and assuming you're going to come in and fall into dishonor, and they're already got post-judgment interest rates. And list of other sureties. Click on sureties. It will take you to fms.treasury.gov. There are the left side. There on the left side, you will see sureties listing admitted, reinsurance, and forms. Click on forms, and you will see reinsurance agreement for a Miller Act performance bond. The Miller Act performance bonds, these are the ones that insure and protect the federal government from any harm, damage, or loss they may encounter by these agents and agencies charging up your estate, okay? Remember, anything they can do, we can do, all right? We are the source of their authority. And so if they're doing it, you can do it. Reinsurance agreement for a Miller Act performance bond, SF-273, and SF-274 payment bond, and a reassurance agreement in favor of the United States, SF-275. See how it's got to be in favor of the United States? That's to make sure the federal government has not caused harm, damage, or loss. All right? And so when you do the when you do SF 24, 25, and 25A, you also, even though you're at the lower county, city, state level, you also have to create the SF 273, 274, and 275, and that is to reinsure or assure that the United States won't be causing any harm, damage, or loss, the federal government. And a list of admitted reinsurance pools and associations and Lloyd's syndicates. Remember how I told you that they were part of the Lloyd's of London? All right, the Standards & Poor's is directly linked to the Lloyd's of London, which is the largest insurance corporation in the world. And they insure all 3,000 plus counties and all the cities within those counties, all right? That's what risk management is all about. Now, if you just look at risk management on its face, it'll take you years to tie it to the Lloyd's of London, but I guarantee you, after some due diligence, you will too also find the same that I have found, is that all 3,000 plus counties throughout the United States and all cities, anybody using risk management or any other type of insurance company is directly tied to the Lloyd's of London. All right. You will also see a list of the Department of the Treasury listing of approved securities, Department Circular 570. Okay, this is important. Department Circular 570. All right, from the Department of Treasury. All right, this is the listing of approved securities under Department Circular 570. And that's where you're going to find these securities right here, these bonds. U.S. district courts are buying up the state court default judgments. What are they buying up? Let's help people out. What are they actually buying up? They're buying up default and dishonor. That's what they're buying. They're buying up the dishonored instruments, okay? So they can monetize them. So they can sell them to a third party and turn it into a retail investment portfolio or a mortgage. That'll later be a mortgage-backed security, all right? So the district courts are buying it up from the lower courts. Now you understand why the district courts, when you go on appeal, really don't give a shit what the lower court did? Because it really doesn't have anything to do with what they're doing. You're just quibbling. You're in there just, oh, I have rights, I have this, I was denied, substantive rights violations, and I was denied my civil rights, and I was denied administrative procedures, and yada, yada, yada. And they really don't give a rat's ass what you're talking about. Because your appeal, guess what? It creates more bonds. They love it when the lower courts screw you. Or when you screw yourself, I should say, in the Article 1, Section 8 military tribunals that are really just banks. They love it. They love it. And they love the fact that you're going to quibble and carry on, because you're never going to come reclaim your securities. You're going to abandon them. So they don't give a shit. They rule in your favor. They rule against you. They don't care. They don't care. Because you're of unsound mind. You really think that you're this in rem, inanimate object, this thing that belongs to the United States, which is a debtor. And you're standing in as the debtor, as the liable party, never realizing the distinction between you as a man and that thing for what it is. U.S. district courts are buying up state court default judgments when you refuse to pay or dishonor the debt. All right. Now people are going, well, Derek, you always tell us there's no money. How do you pay? How do you pay? It's your signature. It's your intent. Such a beautiful thing in this fictitious monetary system. It's your intent. It's your intent, and you telling them to utilize your exemption for post-settlement and closure. For post-set-off and closure. Because you're backed by the full faith and credit of the United States, and now that you understand that everything's tied to penal sums and penal bonds and the penal code with all these statute codes, city ordinances, rules, and regulations, do you really give a rat's ass about what they're alleging? No! And the one that's alleging it anyway is a district attorney, the United States Attorney's Office. Were they there when it happened? No! So everything they're doing is hearsay. They don't swear under the pains and penalties of perjury on anything. They're doing what's called notice pleading. Then you go on and argue and you start the controversy, and now you've created two parties. Now there are two parties. Remember, those lower inferior courts were created for one reason, and one reason only: to settle contract disputes where there be controversy. And you just walked in and created all fucking kinds of controversy. You claim to be the thing. And under the doctrine of idiom sonum, it looks the same, sounds the same, must be the same. All right, let's rock and roll. We got us a debtor, boys, and we can now sell those bonds. We can now sell those GSA, SF 24, 25, and 25A to a third-party investor. And we're invested in the mortgage-backed securities. Retirement's looking sweet, boys. It's looking sweet. Right? All right. Contractors and insurance companies are bidding on the default judgments with a bid bond. Then a reinsurance company comes in and purchases a performance bond as a surety for the bid bond. The performance bond is then underwritten by a payment bond. This is usually done by an investment company or an investment banker. When these bonds are pooled, they become mortgage-backed securities, or security bond or surety bonds. They are then put on the bond market through TBS, the Bond Market Association. All right. The great news is you're entitled to the bid bond, the performance bond, the warehouse bond, the promise to appear bond. You're entitled to all of it, because none of it would exist if it wasn't for you. They hypothecated your credit into existence using your good name and your credit worthiness. They couldn't have got it from anywhere else. It's yours. And you can go back and claim all this. These bonds are also sold as investment securities through brokerage houses or insurance companies. Cicero, Securisoror, is one of your biggest international securities companies and is located in South Africa and have acquired Gray Security Services. Cicero, I think that's how it's pronounced, Securicor, Securisoro, was formed from the merger between Cicero PIC and Group 4 Falk, FALK, which was completed in July of 2004. Cicero operates in 50 different countries. All right? This is massive. This is international, guys. This is huge. All right. Give me a second here. Need to wet my whistle a little bit. Starting to lose my voice. Reinsurance is defined as insurance of all or part of one insurer's risk by a second insurer, who accepts the risk in exchange for a percentage of the original premium. This is all Admiralty Maritime. It's all law of merchant, law of mercantile at its finest. Okay? This is why going and reading the Clerk's Praxis will help you out immensely. It will help you out immensely to go read the Clerk's Praxis, because nothing has changed in all those years. Nothing has changed. It's the same. Also termed reassurance. The term reinsurance has been used by courts, attorneys, and text writers with so little discrimination that such confusion has arisen as to what the term actually connotes. Thus, it has so often been used in connection with transferred risks, assumed risks, consolidations and mergers, excess insurance, and in other connections that it now lacks a clear-cut field of operation. Reinsurance to an insurance lawyer means one thing only: the ceding by one insurance company to another of all or a portion of its risks for a stipulated portion of the premium, in which the liability of the reinsurer is solely to the reinsured, which is the ceding company, and in which contract the ceding company retains all contact with the original insured and handles all matters prior to and subsequent to loss. 13A, John Allen, Appelman, and Gene Appelman, Insurance Law and Practices, Section 7681 at 479-80, 1976. The laying of a risk by means of reinsurance traditionally serves three basic purposes. First, reinsurance can increase the capacity of the insurer to accept risk. The insurer may be enabled to take a larger individual risk or a larger number of smaller risks or a combination of both. Secondly, reinsurance can promote financial stability by ameliorating, improving the adverse consequences of an unexpected accumulation of losses or of a single catastrophic loss or losses, because these will, at least in part, be absorbed by reinsurers. Thirdly, reinsurance can strengthen the solvency of an insurer from the point of view of any regulation under which the insurer must operate, which provide for a minimum solvency margin, generally expressed as a ration of net premium income over capital and free reserves. P.T. O'Neill and J.W. Wolnacki, The Law of Reinsurance in England and Bermuda, 1998. All of the performance and payment bonds are regulated and controlled by FAR, F-A-R, Federal Acquisition Regulations, which are under Title 48, Code of Federal Regulations, CFR 28.202-1 and 53.28H. You want to understand what we're doing and what we're talking about, this is what you really need to go read. Title 48, CFR, Code of Federal Regulations, 28.201-1 through 53.228H. That's what you need to go read to understand this, okay? This is the statutory equity that I was telling you about that exists. It's here. It took me reading Henry R. Gibson's Suits and Chancery, Subrogation, Exoneration, Suretyship, and Substitution to understand it and to be able to see it for what it is. But in here lies your statutory equity. It's been provided for you statutorily, all right? These bonds are being used in cases where it is desired to cover the excess of a direct writing company's underwriting limitation by reinsurance instead of co-insurers on Miller Act performance bonds running the United States. These FARA, Federal Acquisition Regulations, come in two volumes. Volume 1 is approximately 1,326 pages, and Volume 2 is 823 pages long. These should be consulted and read before these bonds are used. The Miller Act is founded in Title 40, United States Code Annotated, Sections 270A through 270D1, and is federal law requiring the posting of performance and payment bonds before an award is made for a contract for construction, alteration, or repair of a public work or building. The surety company issuing these bonds must be listed as a qualified surety on a Treasury list, which the U.S. Department of the Treasury issues each year. It seems I sent some of the blank documents in the attachment on this. Sorry if this is a duplicate for anyone. Have a good day, Lynn. I think all this information applies not only to prisoners, but to children under welfare services. This was a response from Walter Bierney, who has provided us with all the CAFR information, the Comprehensive Annual Financial Report for cities, counties, states, and etc. otherwise, known as the other set of books. This is the books on the private side. That's the CAFR. Now, you used to be able to go see the CAFR report, like the superintendent of the school would get a CAFR report. The city and county board would get the CAFR report. Now they kind of hide it because of Walter Bierney. Walter Bieren, if you go on YouTube and look up Walter Bieren and listen to his discovery about the CAFR, the Comprehensive Annual Financial Report, you will learn a lot. And those are the funds that are rightfully due and owing to we the people. They're on the liability side of the ledger because nobody's using their exemption to move them over to the asset side of the ledger so they can be debited. Okay? And with that said, I think I'm going to take a break. My voice is wearing out. I hope that I've given you a clear explanation and some information that will help you ascend to the mind here. And I'll come back later on today. This document here in particular was created in 2010. Gene Keating, who I followed years and years ago, but I just couldn't keep up with him. I couldn't understand what he was talking about. I wasn't learned enough then. I am learned enough now to comprehend and see what he's talking about. So again, this was published in 2010. So don't take it as the Gospel of John or the Gospel of Paul or the Word of God. Go and do a little bit of due diligence. But I'm telling you right now, the system hasn't changed. They may have added a few more entities and diversified themselves in a way that it's harder to track them down. But the system ultimately is the same. It's the same. It's always been the same. All right. So hope this helps you guys out. For those of you on TikTok that view this, that want to review it on my Facebook wall, so far Facebook's been leaving them up. I think that's amazing. Over the last 6-7 months, they've taken down a lot of my videos, but over the last couple of days, they've been leaving them up. I don't know how long they will leave them up. So if you would like to go download them and enjoy them that way, strongly encourage you to do so. Again, I'm not here to change anybody's fucking opinion. I'm not here to change your mind. You all have free will. Do whatever the fuck you want. Go in there, argue, quibble, and do stupid shit and win stupid fucking prizes, or learn the rules to the game and become the champion of we the people and be about the Heavenly Father's good works. The choice is ultimately yours. All right? Evil prevails because good men stand idly by with their head in their hand doing nothing other than playing with their tweeter. So it's time to shit or get off the pot. Drop your cock, grab your socks, get the fucking work, or shut the fuck up and stay the fuck out of our way. That's what I'm saying. All right. I love you guys. Talk to you soon.